Not I picked it. But the problem is my junior is advocate on record who is ill, and the letter has been addressed by the petitioner to me. Your lordship kindly accept or can adjourn the matter.
You want what,
Non-prosecution
withdrawal?
instruction for withdrawal. But the same has been addressed to me.
But it should be addressed to the client,
Uh,
to the
The
advocate.
advocate on record, my lord. That is why, my lord, at the outset, my lord, I have said.
What do you want? Not today will do, or should I record your name and
Your lordship can record my name. Because the advocate on record, due to illness, hasn't come to court today.
you have not accepted the wakalatnama?
No, my lord.
This does not hold good then.
I leave on to your lordship.
I'm making it not today. Come
My
tomorrow.
lord.
Not today করে দিন এটা ওনাকে ফেরত দিন।
Not in that even cannot, since she is ill, my lord, can day after tomorrow.
Day after tomorrow করে দিন। Next.
Much obliged.
I'm for the state.
Lordship, I'm appearing for the petitioner. There is a small correction in the audit.
Be Chief Judicial Magistrate, not additional.
Yes.
लिखे नहीं। There is a, this matter has been mentioned. No mentioning now. Matter has been called on. Don't
My lord, it is extremely urgent, my lord.
please don't mention now. You should have come before the list was called on.
My lord.
Yes. Anything else you want to add, Mr. Guhatapur? Then I'll close.
My prayer is that, my lord, I think, my lord, RBI presence is required. Because, my lord, RBI will, my lord, have
Unnecessary. If you have any more submission to make, please make that. RBI's presence is absolutely not required. That I will say.
for the argument, my lord, two judgments I want to cite, my lord. One is, my lord, the line of, my lord, transport and, my lord, ICICI Bank.
Transfer you have cited already.
In the line of that, this honorable court in GR Associates and others versus the Bank of India. It held that when the assignee step into the shoes of assigner, and with regard to the recovery of that dates minority, that rights. Paragraph 26. Coordinate bank. Only this paragraph is.
Paragraph
26.
26.
Yes.
Yes.
Hence, the acquisition of a financial assets and rights and interest therein by an ERC or other entities mentioned in section 5 envisages the transfer of the entire liability of the transferor bank in respect not only of the asset but also regarding the recovery of it. So that recovery of the debt, my lord, when the NBFC, one NBFC is, my lord, purchasing the another NBFC, my lord, banks, because, my lord, ARC is also NBFC. Right. So when one NBFC purchases, my lord, another NBFC, my lord, that
Right to recover is also transferred.
Yeah.
That means the right to recover is also transferred.
Yes, yes.
Now, in what manner
But,
and
restriction-
in what manner and in what mode that right will be exercised depends on the nature of the statute which will govern the parties.
Yes, my lord, in the school is also saying, my lord, that a right and borrower will not lose his liabilities or lose his rights after transfer. And another one, I have done some research on reading this. On DRT judgment is there, whether your lordship will
DRT judgment, how will
Same,
it be helpful to you?
the same line when it is passed. But the
Edelweiss,
DRT
yes.
DRT judgment will not bind High Court.
Yes,
It will
will
not
bind.
even
I know
have
that, but-
persuasive value.
no persuasive value and authoritative value.
Then district judge's judgment, why should that not be cited? Because they are on a higher
Yeah,
pedestal than. DRT judgment, what
Yes.
for your side?
একটু প্যারা
Which para?
17 টাকে দেখে
Although the two judgments were relied upon by Honorable High Court,
প্যারা 17
that Ghulam Sabir and Piramol.
This is all the more reason for you to approach DRT then, instead of coming here.
No, I am not well.
Since you have placed it, I will record that. That it is all the more reason for you to approach the DRT.
প্যারা 17 তো
Anything else?
প্যারা 17 টা কথা
বলছে দেখাতে না তুই বলছিস এটা।
Anything else?
That's all.
Ms. Ojha, anything else?
No, my lord, none of the judgments relied upon my learned senior friend is applicable here, my lord. The DRT judgment is based on the judgment of
No, I'm-
Piramal, my lord, which is even just for, that is on the basis of the judgment passed in Ghulam Sabir versus Piramal, my lord, which is not applicable here. That relates to the housing finance company, my lord. Another judgment, Transcore, is also not applicable, my lord, because it upholds the validity of SARFAESI Act, except one section. Moreover, this is not here, the SARFAESI Act is not under challenge in this proceeding, my lord. And the ICICI Bank official liquidator also, my lord, probably my learned friend has relied to so that the assignee's right cannot exceed, my lord. But this is not a simpliciter case of assignment, my lord, because asset reconstruction companies are a separate institution. It has a separate identification as under SARFAESI Act, my lord. So it is not a simpliciter assignment where assigner's right is only envisaged upon the assignee, my lord, and assignee cannot exceed, my lord. So that is also not applicable here. See, these asset reconstruction companies they are governed by
Beginning the same-
separate, yes.
But Transcourse and the judgment of the ICICI kindly consider that it has
I
stated
will
everything.
consider it. Ms. Ojha, do you have intention to take any step in the meantime? As regards,
There is already a section 14
yes,
order.
are you going to dispossess or something in the meantime?
My lord, till today, there is already, if it is desire of my lord, if also my lord, that for a week or 2 weeks, my lord, that I can instruct my client to hold their hands, my lord. But they are already
Well,
having
I'll
this.
keep it for orders. On that day, I'll dictate it. Because
Yes,
I will
ma'am.
not unnecessarily hold it and
Yes.
make it CAB. I'll dictate it in full.
Has been good.
ট্রান্সফার আগে থেকে দিয়ে দিয়েছেন রিটেন নোটসটা দিন
No, this is my written notes of argument. Short.
Key.
Written notes of argument.
Dictate note, why are you giving?
Last
Unnecessary.
occasion I paid for that. Short returns.
Very well. Helps. Likhe niye? Heard Mr. Guha Thakurata, learned advocate, appearing for the
Commissioner, the Dhruvan Banerjee is appearing. He's appearing on court 25. So I'm praying for a short passover. Oh,
My lord, Mr. Konokran Bandabada is appearing in another court. He's on his legs. I'm praying for a short passover.
Passing it over. Passed over. Next.
I appear for the petition.
And for the state.
This is for residential electricity connection. Lordship will,
I appear for the respondent number 6. If Milord kindly grants me leave to appear virtually.
Lordship will kindly have page 40 of my application. Lordship may see a map.
But you are not getting because of the objection of the private respondent.
But there is no formal objection, but the authority is saying that there has been some objection and that the line will be drawn.
For the authority. Madam, you are appearing for WBSCDCL.
And for the state.
Who is appearing for the electricity
On
license?
the last occasion, I believe Milord Mr. Devjit Mukherjee on his ground, Milord, perhaps time was sought on the last occasion. I believe he should be appearing.
Also somebody appears, I think. Will be praying for time again.
Only short password one. I shall not pray for
Milord, may I pray for this? Milord, will kindly, if Milord grants me a minute. Milord, the map which my learned friend is also relying upon, Milord, my client is also the owner of some of the plots. We have no objection as to electricity connection being granted to my learned friend's client. We have
Right.
only objection as to any way leave permission. We are not willing to grant leave for any electricity poles to be installed on my premises, which my learned friend perhaps is referring to. That is the only thing we have objections to. Now, Milord, the district magistrate.
That is for the distribution licensee to find
Milord,
out whether any private area is
I'm
being
just
encroached.
recording my stand,
there is
nothing more. I'm not objecting to him getting electricity. Milord, will kindly bear with.
Mr. Mukhopadhyay, what is your stand on this?
He is my senior, my lord. I am not in this panel, my lord. WBSCDCL.
I'm passing it over. Let WBSCDCL come.
Milord, could it then appear tomorrow because we have a writ petition that we are filing in respect of an adjacent plot of land? Milord, then both the writ petition can be taken up
No,
tomorrow or day after, Milord.
Petition I don't know of.
Mukhopadhyay,
No,
in
we are filing it. We are filing it.
The filing. My Lordship may
Yes,
kindly
yes,
take it
yes.
up today. What is happening?
My lord will pass.
passing it over. Yes, next.
Grateful.
Next.
I am for the petitioner, Lordship. Lordship. Petitioner was alleged hooking. His line was disconnected. Both the petitioner's Lordship line was disconnected in the year, Lordship, 2020.
Yes.
Thereafter, the line remained disconnected. Till today, it is disconnected. Lordship. Petitioner went through the trial. The trial court has acquitted both the petitioners. Lordship, kindly take the order. The annexure B. Paragraph number 30.
135 goes. 126 remains.
Yes.
Paragraph number 30, Lordship. This means that the season is 5 to 7 according to season will season with the season. In this case, it is also seen that the place of occurrence was not identical. The complainant or his associate season and his place of occurrence.
तो क्या चलो कि ना
No photography of the alleged shooting is took or produced or later. The accused person is to be not from the observation. Thereafter, by the order, they have been acquitted. Thereafter, petitioner tried to get the line assessment was due. Now, Lordship, what has happened?
If it can now shop Tushar Kanti dottin na hai. That
Section 3 is 24.
Yes.
2026, the CFC authority all on a sudden went to the spot of the petitioners. When the line remained disconnected since this time, they have not reconnected. That is on record. Today, the line has not been reconnected. They have made another assessment amounting to rupees Lordship 17.
that has been made.
Hereafter, appear before the admin officer Lordship. By and subsequently they have passed the final. For last 6 years, the line is disconnected. In the meantime, they had gone and made these calculations. Now let's
Yes.
My lord, the petition.
another thing. There is one Supreme Court's prediction also. If after acquittal, the special court doesn't ascertain the amount of civil liability, by the SC. That also has not been done.
My lord.
What is the High Court judgment? That needs to be seen first, because that is relevant. That is relevant. Whether in this case also,
May I
whether in this case also 126 proceedings were earlier initiated, or this was a case of no initiation of 126 at all. That will be a difference. Yes.
My lord, the meter of the petitioner originally was disconnected on 2020 for tampering the meter. Thereafter, my lord, on 2021, one Tusharkanti Datta's meter was disconnected for catering connection to the petitioner long back. Recently, my lord, upon inspection, it was found that petitioner's number 2, from the meter petition number 2, my lord, the petitioner was being catered electricity. Petition number 2, that is the connection of Mr. Wahid. And because of that, my lord, the inspection done, the provisional assessment was done, and final assessment, my lord.
Petitioner number 2 was doing what?
Drawing electricity.
Petitioner number 2 was drawing electricity illegally from where the petitioner, this my lord, Muhammad Said, was being catered electricity. This is the third instance. Initially, Said's meter was disconnected on 2020. Thereafter, Said was found being obtaining electricity from Mr. Dotto. His meter was disconnected. Thereafter, he was found deriving connection illegally from this Wahid. And thereafter, this Wahid connection was disconnected. Petition number 2.
So why has Sahid also filed the writ petition if Wahid's connection has been disconnected?
And petitioner is fighting.
All the connections are disconnected from 2020.
Very well, but the writ petitioner, the final order of assessment is directed against Wahid and Tushar Kanti Datta.
Absolutely.
So why has Sahid been made a party here? Very well, but this final order of assessment which you are now assessing has nothing to do with Wahid. I mean with Sahid. Then how is he relevant here?
He was the beneficiary and
He may have been the beneficiary in what you think, but the final order of assessment does not direct any payment to be made by Mr. Sahid.
Abdul Wahid is also the beneficiary.
Yes, but I wanted to know the relevance of Sahid, because Sahid cannot challenge the order which has been passed holding Wahid liable to pay charges, because if there was any observation against you that would have adversely affected your interests, yes, but how would you maintain a writ petition? Shahid, I don't find is relevant here. He may be a relevant party. He may be added as a pro forma or something of that sort as a private respondent, but he cannot claim any relief against the CSC authorities or against the electricity authorities because of the final order of assessment not being directed against him. You have to restrain yourself to Wahid only. Wahid may have a grievance that his line was disconnected, therefore, but even if your line was disconnected, it was only your line that was disconnected, not the feeder line or not the cutout through which the line goes to your premises.
His line was disconnected long back in 2020.
Yes.
He is fighting.
Still, even then, after your line being disconnected, you were obtaining supply from this Tushar Kanti Dotto.
And thereafter from
Subsequently,
Wahid.
you started from Mr. Wahid. So now Wahid's line has gone. So therefore, Shahid has come because now this Shahid's appearance here makes your position a little difficult. Because Shahid then shows that Shahid is aggrieved because he was getting electricity through Wahid and his line has been disconnected. Otherwise, Shahid could not have been aggrieved. This becomes difficult. Very well. Come back.
Not any direction upon us, Milord.
No, let him come with the single bench's direction. As prayed for by Mr. Haldar. As prayed for by Mr. Haldar. List. Yes, next.
Item number 8, my lord, I am the petitioner in person. My lord, on the last occasion, this honorable court has been pleased to direct the CSC authorities to conduct inspection as to ascertain the feasibility of the electricity connection. They have conducted the electricity inspection. I was physically present on that premises. They are supposed to submit.
Is 13,725 you have
Yes.
to pay, they will reconnect. That is their
Yes.
good. You are willing to pay that.
My lord, at the last moment, I was eager to pay the entire amount, but there are some personal expenses. For that, I am praying before the honorable court, at least 50% of the amount be directed to be paid, and the rest amount be placed in installment.
You make that request before them. I cannot pass a mandatory direction. You make that request before them. They will consider it in the right earnest because they would also like to have a line reconnected because there are outstanding dues.
Yes.
13,725 is the outstanding and 8,826 is security deposit.
Yes. Your lordship directs the entire amount to be paid. The rest amount, I will, the security deposit amount, let it be placed as installment.
That you make request before them. I'll provide for that in the order. They will consider because I cannot mandate them to enter into a particular kind of contract with you. That has to be done from their end only. They will take a decision whether 8,800 they should be reasonable.
Yes.
It's not a huge amount.
Yes.
You convince them.
My lord, one thing more. If I pay the amount, let them be directed to immediately connect the.
If you pay the entire
reports
within 24 hours or 48 hours, they will reconnect.
24 hours, my lord.
I will give that.
Yes, I'm good.
But only upon payment of the entire amount. If you want to pay
entire amount, I cannot pay. I'm only excluding the security deposit. Only I'm ready.
Then I will not pass that.
No, only outstanding amount can be paid.
Very well, but the
rest be directed
direction to reconnect within 48 hours of paying of the outstanding will not be passed. Then you will have to make a request on them. If they agree to take part of the security deposit and reconnect, they will do so.
As directed.
I cannot fix a time frame when there is outstanding.
No, I am eager to pay the outstanding, but the
is-
security deposit not at the
deposit is
outstanding amount.
Of course, security deposit has to be maintained. I cannot make them connect or reconnect without ensuring the security. That will be because that is required by law.
Ma'am, my lord, the Supreme Court judgment says that if the outstanding dues are paid, then there is a
Security deposit is
no
not
hindrance
required
to.
only in cases where you yourself are the consumer. you want a supply to be reconnected in your name instead of the name of your father, which includes a transfer.
Yes.
Therefore, it is a new supply. If it is a new supply, security
No,
deposit.
if I don't transfer the name, if the name is in the name of the consumer itself, then there is no
that should
dispute.
not be a
I
problem.
don't want.
At present, I can assess them because his prayer is for transfer in this writ petition.
Very well. You take instructions then. If he wants, if he doesn't want it is in his name, if he wants it in the name of.
Or
his
let
family,
him make an application before the
not
authority.
required. He's there before the court. You can take instructions and come back. Will that do then?
Yes, yes, yes.
Please take instructions.
Deposit amount.
The petitioner. Not today. Yes.
Item number 10, my lord, I am appearing on behalf of the private respondent borrower. Lord, Mr. Shankar Prasad Dalapati appearing in this matter. Mr. Shankar Prasad Dalapati appear in this matter. My lord, kindly make it not today, my lord.
What is this matter? Section 14, you don't have any, you have nothing to say here. It will be the direction will be upon the state to dispose of the section 14 application. Passing it over, call him. Passing it over. Next.
11? No, 11.
No, 11, he may not be the borrower. Call 11.
Item number 12,
But item 11 we have for the state, my lord.
Item 11.
Same, my lord. Similar matter, my lord.
Item 11 order to record for. Where is your section 14 application? Before the DM or ACG?
ACGM.
Where is that? This writ petition seeks expedition.
Item 12, Your Lordship, I am appearing for the state of West Bengal. I'm seeking some time to seek instructions, Your Lordship.
What instructions you dispose of the section 14 application? What instruction will you take?
Lord, I am appealing for the
It's a section 14 application which is pending, you dispose that of. Yes,
My lord, I am appearing of the standing led by my senior. My lord.
very well. Madam, dispose of the section 14 application. That is the direction which I'll
Very,
be.
very well, Your Lordship. Very
What
well.
instructions in this? লিখে নিন ওই মিস সিআরএল কেস নাম্বার 88 of 2025 হয়ে যাবে, বাকি সব সেম থাকবে। বারুইপুর সাউথ 24 পরগনাস, ঠিক আছে। মিস সিআরএল কেস নাম্বার 88 of 2025 আর ডেট সেম 7 জুলাই 2027, আগে ছিল তাই, সেম অর্ডার। নেক্সট নেক্সট now. Yes, item 10, you are appearing for the state.
I am 13, my lord.
10, sorry, 13.
13, my lord, I am for the state. Usual order may be passed.
লিখে নিন, বসে যাচ্ছেন কেন, লিখে নিন। ওই মিস সিআরএল কেস
My lord, I beg to appear for the private respondent.
page 26. Yes,
এটা 14 বাদল জানা।
My lord, in this matter, Mr. Naik is appearing on behalf of the WBSCs.
Mr. Naik,
Srijan Naik. And I am praying for short pass.
passing it over.
I think my lord, she prayed for consideration of the representative.
I
It's not because my lord, according to her, I don't have any license, but the quotation amount was made from the
Very well, that
electricity.
they will consider, it's a factual thing.
Yes.
I can direct that then.
My lord, let him come. I will inform. I will inform.
দিয়ে দিন, এটা পাস ওভার করে না, সব পাস ওভার হয়ে যাচ্ছে। নেক্সট
ম্যাডাম কটার দিকে ডাকো?
নেক্সট
I'm appealing for the license. I'm for the state member.
not this week, not this week. Next. Please take the mic, you are not audible. Yes. মাইকটা অন করে দিন না। Push step.
My lord, yes. My lord, the petitioner has obtained loan from the bank, my lord, for house building, my lord. The loan amount by the petitioner failed to pay, my lord. 13-2 notice has been invoked, my lord. Demanded sum of rupees 18,74,000 and odd, my lord. My lord, they issued symbolic possession, my lord. Possession has not yet been taken, my lord. In the meantime, my lord, petitioner has filed an application before the bank authority, my lord, for one-time settlement. My lord, they are ready and willing to pay the said amount by easy installment. My lord, section 14(2) notice has been issued, my lord. But section 14(2) notice has been issued on 21/4/2026, my lord. But my lord, that is
Yes, but how will
Page
the
26.
High Court intervene here? Section 14, you have to challenge before the DRT.
My lord, DRT I have filed, my lord. My lord, this is my application, my lord, now 14, my lord. For one-time settlement, my lord, I'm ready and
Settlement also, bank cannot be directed by the High Court to enter into one-time
but
settlement.
to consider my representation, my lord, that can be done, my lord. Your lordship can consider my.
Without any mandatory order, that can be done. I will not mandate the bank to do it.
No, my lord, I am not praying for that. That is not my prayer, your lordship kindly. And my lord, till then, my lord, let them not take possession, my lord.
That I cannot. That exactly I cannot. I will not pass. That will be entertaining the writ petition. I cannot.
My lord, your lordship then kindly direct the respondent bank to consider my representation.
Bank. Who is appearing for the bank?
State Bank of India. State Bank.
लिखे नहीं.
I'm for the petitioner, my lord.
Mr. Devanjan Mukherjee is for CSC authority. He is engaged in court number 39.
He is engaged. How? What will happen? All matters are getting not passed over.
Passed over.
Then, my lord, not today. Not
today.
today.
Next.
Not today, my lord.
For the distribution company,
My lord,
report
I
has
am
already
here
been
on
filed
the
as per
petitioner, my
direction. Matter has come after.
My lord, the petition earlier moved it page 14. Page 14, my lord.
1/4.
1/4, my lord.
Yes.
The non-payment of outstanding bill, earlier direction passed by the Honorable Court, my lord. The petitioner entitled to dispute before the RGRO, my lord. Thereafter, the petitioner moved before the RGRO ombudsman, my lord, page 31.
Page 31. Yes.
31, my lord. The ombudsman reaction upon the licensee, this the WBDCL, my lord, shall cancel the outstanding bill dispute and challenge the appeal petitioner on earlier direction, my lord. Thereafter, page 34. Issue a disconnection notice. Thereafter, petitioner made a representation, page 35. I am prepared for direction to consider my representation, page 35.
My lord, in terms of the order passed by the landed ombudsman, bills were regenerated. That is page 33 P3. It was served to him. In spite of that, he did not make any payment. Thereafter, disconnection notice was served to him long back, and even then he did not make any payment in terms of the order passed by the landed ombudsman, and thereafter his line has been already disconnected on 25/2/2026. Report has already been filed, which is on record. In terms of the order, we have already filed a report. It is there.
There was a earlier direction of
Yes,
giving a
earlier
report.
direction passed by Lordship, Mr. Kapoor, and we have filed a report stating all the facts.
There is no report on record.
May I hand over a copy?
And there is no order recording that report has been filed.
In terms of the 2nd February 26 order.
But where is the report? This is a copy of the report.
Yes,
Because
copy of the report.
where is the original report?
This is the report. This is the report.
Where is the original report? This is just a copy. Where is the original report?
My
This
lord,
is
it
just
is
a
the
copy.
report. My lord directed to file a report only.
Yes, but where is the original? It has to contain the original signatures. You cannot give a photostat copy as a report.
It was, I think, filed, my lord.
It was never
Not
filed. The last order was on February 2, 2026 by Justice
Yes,
Kapoor,
yes, my lord.
directing you
That
to
is the
file a
last
report.
order.
Thereafter, nobody appeared. There is no recording.
Yes. It is copy of the report. If
Where
you
is the
honor,
original?
it is only, it is printed online. If you honor directs, we will file it or not.
It is not printed online. It has it contains signature, but that is a photocopy of a signature.
Photocopy of the report.
Then
Well, in terms of the notices, disconnection has already been done, and his prayer is to consider the representation. So, writ petition has become infructuous. Moreover, he has not paid anything.
On page 31, direction upon the ombudsman,
By the ombudsman.
LPS charge, remove the charging of LPS charge from October, the date of replacement new healthy meter, my lord. Not comply by the ombudsman order.
In terms of the order
LPS
passed
charge
by the
including
wait, let him conclude.
My lord.
page 31, direction upon the ombudsman, direction of the WBDCL to comply the charging any LPS charge.
What have you prayed for in the representation? Representation is of 2023.
35 order.
And when was the order of the ombudsman passed?
Order passed on 16 December 2021.
21 direction you have not complied with. They have disconnected in 2023. What they will consider? If
Without
you pay, they will reconnect.
without opportunity of hearing, my lord, the bill raised by the WDCL.
After the ombudsman's order, there is no question
What
of any
opportunity?
further hearing. You have already been heard by the grievances.
Ombudsman direction upon the WDCL remove the LPS charge, late fine payment charge.
You have not challenged the order of the ombudsman. If they have done something wrong, then in that case, you should have said that that is not your representation.
Twofold order, my lord, passed by the ombudsman, my lord. LPS charge, my lord, replacements of new meter. WDS not complied, the new meter installed by the new meter.
We have complied, my lord. New meter has been installed. In terms of the order passed by learned ombudsman, bills have been regenerated.
My lord, consider my representation in accordance with law.
Consider. You have not paid anything. They say they have already installed a new meter.
My lord, you can see the
They
report.
claim a absurd bill, my lord. LPS charge not removed.
Report
not that this
Copy of the report.
New meter has been installed.
Give a copy.
When I pray for instruction from my client, my lord, not today, my lord.
That they have suspended the proceeding together.
Yes.
WBACDC.
লিখে নিন।
But I'm for the opposite party, my lord.
Yes, there is a mistake in the order.
My lord, that I have seen, my lord, but that does not negate the order, my lord, because there are other reasons which have been supplied by your lordships, my lord.
Shall
That
the
has been
matter,
recorded by the learned court below also, my
I
lord.
missed the noting because the handwriting is such that even I could
That-
not make out. At that
Lord,
point of time when I was going
That I
through
do
it,
understand, my
neither were you there.
grateful, grateful.
Somebody else was there who did not point out that. It does not appear to be bed rest at all.
Yes, yes.
my lord.
The way in which R is written and B is absolutely. I thought it is the name of some medicine. Till such
Yep.
time that you pointed out that it is bed rest, then
My lord, only the doctors and chemists of honors can understand their prescription, my
I
lord.
absolutely did not. I went through the medical certificate. That is why I wrote that there is no indication of bed rest.
My lord, may kindly,
Still does not appear to be bed rest. It appears like the RXR.
yes.
Shall the matter be recalled and released today, or it will be heard by this court only?
If the conclusion changes, then it has to go. If the conclusion still remains despite the correction, then there is no
Grateful,
point.
grateful.
Yes, sir. I will have to release it if the conclusion ultimately changes.
Okay. Let my learned friend conclude, then I can.
My lord, may kindly appreciate, my lord, that in this matter, my lord, what has happened, my lord. If I briefly recapitulate the facts of the case, my lord. It's a matrimonial dispute which has been going on since 2000, my lord. The degree for divorce has been granted. After the degree of divorce has been granted, the wife has filed an application for permanent alimony, my lord. That was
When is the
rejected by the
next
court.
date? When is the next date before the learned trial?
27th, your lordship,
27th of this month.
this month.
So till now she is not well.
Still now,
This was
He-
the
December, my
condition.
lord.
Why are you unnecessarily fighting? Go and give your
the
evidence and finish.
order 26 rule 4 at least, kindly consider that part. For all these years, I have never preferred any application of such kind, your lordship. Now the situation is such that I have to, because she is not willing to come because of her health. Last day she got a trauma because there was a chest pain, and that sorbitate has to be supplied. But brother was there. Brother is not always available, your lordship. I cannot take the responsibility. Order 26 rule 4 beyond jurisdiction, your lordship.
Beyond jurisdiction is no point. It is not beyond jurisdiction.
As
at all.
per
How can
family,
you say it is
I
beyond
have I have brought the Family Courts Act, your lordship, as well. Kindly consider that part, your lordship.
Mr. Purohit, I am recalling it to go and get it flushed out there.
Right.
Because there is a mistake evidently.
My
There
lord, may
was
kindly
bed
see,
rest.
my lord, paragraph 6 of your lordship's order, my lord.
Seen that.
There are
but
other reasons also, my lord.
And then this reason played the most. This was only an additional
My lord, may
supplement.
kindly, if I may point out to a few things, my lord. My
Because
lord.
in any case, it's not going to harm
Nothing.
anybody. You will have a chance before the other court. Let it be
Grateful,
heard.
grateful.
In any case, it won't be proper.
Grateful.
Since
My lord,
Yes,
item number 10, my lord.
just the direction to the ACGM to dispose of section 14.
May I suggest one thing, my lord? Your lordship have vast knowledge about this. I don't want to argue on any point of law. But my lord, my client, it is my instruction that the matter to be settled within a 15 days or 21 days. Lord,
I will give 1 month time to dispose of. In between, you can settle
Lord,
it.
kindly keep it pending. In the meantime, both of us will settle the issue and we will come back.
I'll communicate
Because
with
my lord,
the
the
bank, my lord.
multifarious litigation, it is not expectable to both of us. But it is my instruction that the matter to be settled. Because
If the matter is disposed of here, my learned friends kind will get 1 month opportunity to settle the matter.
that is why, my lord, and don't dispose of it. Kindly keep it pending. We will come back within 1 month. If pending থাকলে settle হবে, নাহলে হবে না। হাইকোর্ট এটা তুমি বোঝো না।
But on what ground will I adjourn? It is a matter for expeditious disposal. I cannot unnecessarily adjourn it
Lord,
because
kindly
you don't,
record.
as a borrower, you don't have a right of audience. In section 14 proceedings, it is now settled. You
Lord,
don't have a
kindly-
right of audience.
I know, my lord, your lordship have vast knowledge in this issue. Lord, kindly record my submission and I will come back within 1 month.
No, but I cannot keep it pending. I will dispose it off. I will grant you liberty to settle if you can settle in the meantime. I will say that. That will help you.
I will, sir.
We appear for the central government in this matter. Respondent number 1, my lord. This is
কি এটা কিসের জন্য দিয়েছে? না তো এটা লিস্টে আসছে না, এটা লিস্টে নেই। नहीं तो yes.
Answering respondent in this case, I believe the bank, my lord. Bank is not represented, my lord. I represent the
No, before the
Union
Lok
of-
Adalat, nobody appeared.
Nobody.
लिखे नहीं
Full.
23, I'm for the petitioner, ma'am. But
Why it is not sought affidavit?
But
Where,
it-
my lord, for shifting, my lord, joint inspection was made, route was, my lord, decided, selected. Our, my lord, statement is this, my lord, the petitioner did not want to, my lord, sign it, accepted this, my lord, route.
but my submission is that, my lord, at the time of inquiry, my lord, my mother was there. So I was not present, my lord. For this reason, my lord, my mother did not sign any papers, my lord. So my request is that your lordship kindly direct the authority when the shifting work will be done, my lord, before giving notice, 24 hours notice, but to the petitioner and petitioner in presence of the petitioner, that should be done, my lord. This is my.
Want shifting or you don't want shifting?
I want shifting, yes, my lord.
You are agreeable to do shifting?
Yes, my lord.
Only, my lord,
They have.
it was decided, but at the time of, my lord, when they were requested to put their signature, my affidavit is they, my lord, petitioner refused to sign, but now he is saying that her mother was there, his mother was there, therefore mother did not sign it, but they want shifting. Virtually, they are accepting
My
this.
prayer is the shifting, my lord. In my writ petition, my lord, the connection has been given, my lord, on the plot of my land, my lord, to the private respondent. And
Page
said-
4, my lord, only last paragraph, H, that's our, my lord, only difficulty. However, the
So if they want shifting and you are agreeable to shift, what is the problem?
no problem,
Yes,
they
my
now want that the notice to be given, prior notice.
Prior notice to be given, my lord, as petitioner with present, my lord, at the time of shifting procedure. This is my submission, my lord.
You have, I mean, pinpointed a place where the
yes.
Installation will be shifted.
Place was decided, selected, route was selected, but her mother, now he is saying that our mother was his
Now,
mother.
if you subsequently, since there is no signature, if you subsequently object to the route or to the place.
No, my lord. For this reason, my lord, my prayer is that, my lord, in presence of the petitioner, that shifting proceeding will be done.
Presence of the petitioner at the time of shifting, when everybody goes, you start objecting, that will be dangerous. Then you file an affidavit saying that you are agreeable to the place selected by the WBSCDCL authorities and shifting
my
can
lord,
be done. It cannot be on ifs and
But
buts.
before that, my lord, one order is required, my lord, as the section officer is to be meet, my lord, to my client, my lord.
Again, they will go. They went to your place. They inspected. At that point of time, you did not remain present. The person who was present refused to sign. Now, for your ipsit dixit, the persons will have to visit again, and it cannot be according to your leisure.
So, my lord, this is
Be so privileged that every time the authorities will have to go merely because you will not sign on one day. One fine morning you decide to sign.
But when one day, my lord, they have
One day for what?
they,
Went
after
they went there one day because of the court's order.
without notice, my lord, he was in service, my lord. His mother was present at the time.
You serve notice before going.
Well, by instruction, it was they were present. That
they were present will not be somebody who is an aged woman may not understand. Then it is your fault. You should have gone with notice. Without prior notice, if you go, the person.
My lord, I have given all the papers. All prior notice was there. They accepted it. Route was decided. selected, that I have also
When was
handed
prior
over.
notice given? Show me from the affidavit
Yes,
that you had given
not,
prior.
not all these papers were not with the affidavit, but I've given the copies to
Doesn't
my
appear,
learned
because
friend.
if prior notice had been given, they would have been present. Then
But
you
my lord,
don't-
once more the notice, prior notice to be given and shifting to be effected.
No, then shifting to be effected once I pass this order of shifting and then he comes and objects, then it will be a difficult situation. You please, both of you, please start out a way that this is the way in which shifting is to be done. If you cannot take a call, then in that case it will have to be referred to the DM. Because I will not be entering into this disputed question of fact where it is to be shifted, which is the
My
right
instruction, my client's instruction is that, my lord, he has no objection for shifting, but
to file an affidavit to that
but
effect.
he
I
has
will take
stated
on
that,
record.
my lord, when the shifting procedure will be done, my lord, he in his
File an
presence.
affidavit to that effect. I will take that on record and pass an order. On your roll saying I will not do that. Decide it.
So, my lord, if your lordship be pleased, my lord, one order may be given, my lord. If your lordship, my lord, kindly direct me, my lord, to my client, my lord, to the petitioner, my lord, to meet with the SS, my lord, for to know about the shifting details for this reason, my lord. So it is.
The affidavit does not disclose that.
Yes, yes.
No, they have.
We have
Affidavit has stated that, my lord, he has not signed.
Page 4.
My client, in absence
Page
of my
4.
client, he has not signed.
Further complaint that in
They have only
compliance-
stated that.
in connection with this present proceedings, a fresh inspection was conducted by the station manager Usti along with JE and technical personnel in presence of both the parties on 12 to 26. That during the said inspection, spot inquiries were made and a sketch map was prepared indicating the situation. That both the existing alignment and the technically feasible alternative route that is there.
A report একটু একটা লিখে দিন একটা। That will serve. He will have his signature.
My lord, item number 24 and 25, I am for the petitioner, my lord. My lord, in item number 24 and 25, practically the allegations against the petitioners are the same. In item number 24, allegations was that consuming electricity from direct hooking from the nearest LTOH line. And thereafter, they raise the demand, and Lordship will find the demand at page 51. (18 lakhs 80,193). Thereafter, we raised the objection within the time frame 15 days, and the provisional assessment was done. And in the provisional assessment, they have reduced nearly 4 lakhs.
Final assessment was.
A final assessment were done, and we have paid the entire payment in respect of this disconnected line.
14 lakh you have paid.
Everything paid, and we have got the receipt, and my landlord friend also knows that one. Now, my lord, what happened, my lord? Here the connection has not been restored due to in item number 25, the next matter. In that matter also the allegations were same in respect of a domestic connections, wherein the petitioner in item number 24 is also in item number 25 along with his brother. In that case, the demand raised, the provisional assessment made, final assessment made. What I am submitting, my lord, I am not against their demand. Kindly I respectfully present that since in respect of item number 24, we have made the entire payment. Well, regarding item number 25, if you lordship kindly, I am praying for a little bit consideration so that we can the electricity can be restored and we can run the business and the domestic line can be restored.
Consideration for what?
Lordship?
Consideration in what?
Consideration for consideration in respect of the amount.
I cannot reduce the amount. How will I? Under what provision? I don't have authority to reduce the amount. That has been done in accordance with the provisions of Electricity Act.
The problem is this. After raising their demand, within 15 days, admittedly, the petitioners could not submit the objection.
That is different. See, if you were challenging the final order of assessment, you have a provision for appeal before the appellate authority.
Lordship.
Now, the final order of assessment has attained finality. You have not challenged it. The final orders of assessment are therefore staring in your face as well as in the face of the court. Now, I cannot set aside here in the jurisdiction.
Then, my lord, can it be, my lord, subject to lordship's convenience, whether his appeal has not been preferred? Whether liberty can kindly be granted?
No, it could have been granted if the writ petition. When was this writ petition filed?
Writ petition was filed, my lord, so far next matter.
21st May 20. No. We second matter.
And when was the order passed?
23rd of March 2026.
3rd March to April.
Same day, 21st May.
21st May.
So
21st May.
We have crossed the limitation. That is not condonable. There are hurdles.
No. Your lordship, that installment subject to, I just leave up to your lordship.
That I can
the installment can be paid.
Make payment in installments,
yes,
if they consider it fit.
Yes, I will. That will be done. That can be done.
And so far the first matter is concerned. Let the connection may be restored against
upon payment of the second installment, because the dues are there.
No, dues in respect of the first matter.
Dues are in respect of the same person, may not be the same connection.
No, not same person. In one matter, the first item, there was a commercial connection in the name of Pratap Bera. And in the second,
Personal connection in the name of?
Pratap Bera.
Yes.
And in the second matter, the connection is a completely different connection. In the name of
Pratap Bera is the writ petitioner even in the second matter.
It's also hooking in the commercial as well as in the domestic. But
Well,
there is
they
a
are
direct
intertwined, it will
hooking.
be difficult.
But that is a
It
it's a
cannot be
second
segregated.
offense. It's a second offense.
Cannot be segregated.
But so far the
Electricity
first
bill-
offense is concerned, they have made payment. But in the interim, they have already committed the second offense, Lordship. And on that
No,
basis,
Malord-
provisional and also the final order of assessment has been
Two
passed.
assessment orders staring in your face, difficult, very difficult. You
But
pay
let them
both,
make an application for
pay
it.
both. You can make an application for installments that they will
That
consider.
has to be. That
And
will be.
maybe after payment of a lump sum, if they consider, they will
Yes,
reconnect.
yes.
Balance you can pay, but I cannot pass a mandatory order. I have
and Malord, then
similar
kindly observe
prayers.
if they agreed with our prayer regarding payment, lump sum payment, and thereafter the installment, the connection may be restored after paying the reconnection charges.
That they will consider and do.
Malord, kindly observe this.
Okay. I will not be able to waive anything. I don't have that right.
No, I am not praying for waiver. I am only praying.
Reconnection charges may not be charged. You said that.
No. I am ready to pay the reconnection charge, subject after completion of the entire payment, installment, lump sum, such whatever it may be. Only thing kindly consider this as, otherwise, again I have to come back for
No. If they make the entire payment, then why the reconnection should not be given?
Well, kindly observe this.
Personal enemy.
Only thing I am praying this.
But so far the
only thing
I am praying. Kindly observe this thing. After making the payment of the installment in respect to the second matter and the reconnection charges in reinstallment charges.
Yes. I will observe that if
That's all.
If entire payment is made, electricity has to be restored.
Yes.
They cannot take the payment and not restore. They can't do that.
But so far the item number 24 is concerned.
Police cases are in respect of 135. So they are dissociated from this final assessment.
Technical problem.
Because that is criminal liability. This is civil.
But there are two reports, one in respect of item number 24, another in respect of item number 25.
Same thing is there in both of them, or different things.
So far the report is concerned, so far the first offense is concerned, there was a final order of assessment against that appellate authority. Appellate authority had to reconsider, they have reconsidered and they have made the payment. So far the first matter is concerned. It is pertaining to their commercial. And so far the second matter is concerned, it's a joint liability not only of the domestic connection but also of the commercial connection. Their final order of assessment has been passed.
Commercial connection in which the
Yes, same.
second offense.
Yes, second offense same. That's why I'm saying. And on that basis, your lordship, so far the second offense is concerned, that has to be considered.
And second, the second writ petition, any challenge to the final?
No, not yet. Admittedly, no.
Different
Actions
action.
of his brother, second matter, brother, as well as the petitioner. One pertaining to domestic connection and the
No,
pertaining.
but how is there a second offense in respect of the same line? You said there is
My
a second
report
offense.
will speak. Report. If your lordship kindly see the report. In the report, it has been specified. FIR has also been lost. The FIR details has been given.
আমি যে বেরিয়ে যাচ্ছ এটা তো বলেই দিচ্ছে
Page 5, page 5 FIR.
এটা কি পড়াবো আমি জজকে পেজ 5
Which report are you reading?
11982, second matter. 11982.
Yes. Page
5.
Page 5.
FIR. Kindly come to FIR.
Yes.
On 20, I do hereby lodge such and such on 22/3/2026. Lordship got that? At about 9:45 when see Shubroto Shen, aged about 38, AE Masada such and such, and others has been village for routine inspection purpose. During it was found that Pratap Bera was consuming electricity dishonestly in his commercial premises. Lordship got that? Fishery by the way of direct hooking from the nearby LTAB connection causing considerable loss of revenue as theft was detected during inspection.
Yes, so the earlier commercial premises and this commercial premises are the same.
Same.
What my learned friend has tried to attention the lordship's attention, in respect of this FIR, all the demands have already been made, payment paid, and there is no outstanding. This is their report.
Subsequently in 2026 and previous one is
There is no outstanding.
Two.
Lordship, can you
One
see?
is first.
This is 7 lakh. 7 lakh and 7 lakh, 14 lakh.
এখানে কত টাকা পেমেন্ট হয়েছে এটা?
Yes, so this page 5 he has paid.
No. Kindly see that 18 lakhs demand raised pertaining to 2025 allegation.
Yes, this is you have paid it later.
Allegation.
This is
And
in
it is
respect of a
subsequent.
later demand. This demand stands. This is a 2025 FOA. কি লিখলেন?
though there is a direction upon the state, but I believe it will not be necessary. Section 14, my lord, application date is at page 31 of November 2025. My lord can pass an order.
Let there be direction, my lord. They will complain.
Not a request, a direction.
I'm appealing for the licensing company.
Phone number 1, 2, and 9 to 12.
I'm for the petitioner led by Mr. Shonagos. I'm praying for not today only. Yes. To file a supplementary, I'm praying for not today.
I am for the petitioner. Early occasion, my lord, kindly order dated 27 2026, para 4. No report has been submitted by the within 2 weeks by the private respondent authority.
Probably, I think he has missed the list.
My lord, I have conduct from my own pocket a survey. The transformer is installed within my land.
I will keep it tomorrow. I think he has missed the list. I will inform him, my lord.
28 I am. I thought 25. In the last occasion, there is a direction of filing affidavit in the form report. May I?
My lord, I have not served any report. Direction within 2 weeks from the date.
Next.
29, my lord, I am appearing on behalf of the petitioner, my lord. Last occasion, this matter was heard by your lordship. And on that day, my lord, my learned senior friend, my lord, wanted to place one order passed in another writ petition, my lord. For that reason, my lord, that on that day, matter was adjourned.
Yes.
My lord, I am placing some orders, my lord.
We should have a copy of this.
কি তোমাকে দিলে পরে আমার তো থাকছে না নাও ওই নাও ধরো জজ সাহেবকে তো দিতে হবে একটা
According to you, the proceedings were disposed of before completion.
Yes, my lord.
That is a-
My lord, without giving any opportunity to file any exception to that report.
Yes.
But that I want to place, my lord, philosophically data.
What is there? Give me a copy.
এটা দেবেন জজ সাহেবকে এটা first of order, my lord, that is the order passed by my lord Justice Prabhashati Bhattacharya in a lead petition filed by the present petitioner, my lord. I am just placing, my lord, that page 3 of the said order, my lord.
Page
3 of the said order, bottom.
Page 3.
However, since a prima facie case for hearing the lead petition on merits has been made out by the petitioners, and it is doubtful as to whether any affidavit by the respondent number 3 to 5, that is the present respondent, my lord, I am appealing, can improve their case in any manner, as the injunction order is already on record and the case more or less have been is depicted in the lead petition. The prayer for filing affidavit in opposition is refused at the present moment. However, in view of the prayer of the adjournment, the matter is adjourned till December 8, 2022, when the matter will be next heard. But the next order is before your lordship that has been filed by my learned friend in the lead petition. The CSC Limited shall take necessary instruction and inform the court in that regard on the returnable date. Learned counsel appearing for the respondent number 3 to 5 with the liberty to cite judgments he wants to delay and to specify what exactly he wants to disclose in the affidavit in opposition if need be. Learned counsel for the respondent number 3 to 5 further contents a service only upon the added respondent ruler substantive is not sufficient since it is a government concern. Learned counsel appearing for the petitioner shall also satisfy the court on this issue on the next returnable date. That means the state should be before your lordship, my lord. State should be before your lordship because, my lord, connection has been given to Ola sub-center, my lord. That is a primary health center undertaken by the government of West Bengal. Therefore, state should be a party. My state should be before your lordship, my lord. Now that
State of West Bengal is a party to the writ petition.
My lord, if the
State is already a party to the writ
my lord,
petition.
party, but they are not appearing, my lord, before your lordship. I don't.
Choose not to appear. I cannot.
Then,
force
my lord,
them to
next
appear. They are a party to the writ
my lord, next order, my lord, that is passed by my lord Justice Kapoor, my lord. May I place before your lordship affidavit of
These are all interim orders. The matter was ultimately disposed of.
Yes.
Directing the district magistrate to pass appropriate orders. How is
then
this
your lordship
relevant?
kindly
This has
come
merged
to
with the
no,
final
my lord.
order.
That is the order of the order. That is a report of the block land and land defense officer. That is annexed, my lord. May I place
Matter has been
joint inquiry report.
Matter has been disposed of by a final order. So how are these orders now relevant? These are all interim orders. These have merged with the final order disposing of the writ petition. The
Yes,
writ
my lord.
petition has been
My
disposed
lord,
of. Now if you concentrate
my
on
lord,
the
district
final order,
magistrate has delegated block development officer and land defense officer to make an inquiry and to inspect the spot. But that has been done and they have submitted a report to the district magistrate.
yes. But the district
But,
magistrate only upon taking the report has disposed of the proceeding. That cannot be. If they have filed a report, then in that case, you as well as the petitioner are entitled to file an exception to the report if you feel so. Now
Yes.
he feels that. You may not feel the same way. He feels that he needs to oppose the report. That opportunity cannot be shut out.
Well,
should
there is
get
a
the
specific observations of the my lord, that is the report of the district engineer CSC Sakral, my lord. They have signed, my lord, that correction has
whatever they have observed, that is not sacrosanct. They may have observed a lot of things, but if he has something to say against that, should he be precluded from saying that? He should be given an opportunity to say that. The district magistrate cannot just take the report and dispose of the proceeding. He has been given an authority to decide. For taking a decision, he has to hear both the sides. if he takes a report and disposes of the
My lord
proceeding.
will send the matter to the district.
I will ask him to dispose it off upon giving an opportunity to contest
My
the
lord, also
report.
to my, also to my,
Of course, you also. Of course, you
and
also.
also the CSC authority, my lord.
CSC authorities own report, they will not.
Because, my lord,
contest.
yes, my lord, they have
filed-
installed the meter, and
We should be heard, They will be heard, but they cannot take exception to their own report.
but this is not the report of the CSC, my lord. This is not the report of the CSC. But
we
report
are
of the
there, we have signed.
Signed, yes, my district engineer has signed, my lord. BDO
Yes, so they have
circular has
also-
signed,
if-
and
let me
BLL
tell you,
has signed.
whoever wants to take exception, if you want to take exception to your own report, you also take. You can file your affidavit in opposition to your own writ petition also. Then in that case.
Well, the report is.
Let the district magistrate hear him, because he could not have acted on the BDO's report without affording him an opportunity to take exception to that. If you want to take exception, you also take exception to BDO's report. But it can't be merely on the acceptance. There has to be reasons for that. That is all that is being done. Say whatever you have to say before the DM. material. I will not indicate any one thing.
I'm grateful, my lord, deeply
Grateful, my lord.
grateful, your lords.
Next.
Active I am for the petitioner. The prayer for new electricity connection objected by the private respondent. The coordinator was pleased to direct the authority to take an inspection, cause inspection. But perhaps Malana friend has on 21st inspection was there.
This is the inspection report. I am for the lordship private respondent lordship.
We found out.
Yes, lordship.
Yes,
Inspection was held lordship on the
all, my lord, the inspection was carried out. My lord, a minute has been prepared, my lord, handwritten, my lord, and hand drawn.
Nobody is having problem with this.
No, on
But
the
they have
northern
given the
side lordship,
consent.
there is a pond adjacent to the pond lordship, there is a road.
Whatever.
Over that portion where lordship the inspection was held, I
I
am
have not gone through the report. Lord.
You take in, go through this and come back tomorrow.
Tomorrow.
May I get a copy of the inspection report, lordship?
There was objection, not only
No, objection.
Give a copy of the inspection report to them.
There, my lord, the private respondent, there is one private respondent in this present writ petition. Lord, there are two or three other objectors also. In presence of all, my lord, the inspection was carried out. My lord, later on, my lord, all the objectors, they, my lord, have agreed to, my lord, give permission on, my lord, the
Give him a copy of the report.
Yes,
so that
yes,
he
yes.
can go
Instead of the
lordship, so
instead of the petitioner, all other respondent and
yes,
lordship.
petitioner,
The petitioner lordship raised objection.
See, my lord, did not express any opinion and my lord,
No, what has happened? May I get the instruction? May I get the copy and come back with the instruction tomorrow?
they have given the proposal, my lord, and that is the then, my lord, report is kept on record.
হবে দাঁড়া না হবে
as prayed for. Next.
For the respondent.
Yes.
Direction for making inquiry and to submit report.
And put in place, external pole is needed. That's it.
7 poles have already been erected.
Yes, that is also pleading in my writ petitions. 150 meters are gap. This is the quotation deposited 2020. I am waiting for last 6 years.
So when will you deposit? When will
After
you
the rainy season,
pole?
after the rainy season, we'll install one pole and give him. The connection is already there. One extra pole is needed. That's it.
No, my respectful submission is that, my lord. I do not have any connection because they install 7 poles and there is a Panchayat road. They install meter in the last pole, but there is a gap of 150 meter to my submersible pump. So I am not enjoying. Kindly have a look. Only I am not disputing. Only have a look. Page 17. Last year on 7/8/2020, where same reason was assigned. Yes, due to rainy season, we could not install numbers of poles.
And what was the order passed on that?
RGRO directed to complete the new connection process. Install.
I will pass an order. If they don't do it, come up in contempt. I'll pass an order. Rainy season means how long will you take? Rainy season, what is the
1 year's gone.
Because you have already done this for last year also. It was the same thing. So rainy season has gone. Second rainy season has come. He has not yet got electricity supply.
Maybe in a month, my lord. Because right now we cannot install poles. The ground is very soft.
Give me a time frame. Give me a time frame because rainy season.
Then I have to take instructions, my lord.
Come back with instructions. Likhen.
Grateful, my lord.
Next.
Item for 14.
Item 6,
Martin, একটু পাঁচবার একটা কল করে দিন তো, সবাই চলে এসে।
But I'm sorry, my lord, this is my mistake. I was in stock of another court.
13 টা কল।
item 6.
Five at time.
Oh, 5. Six, my lord, my application, but page 40 is a map.
Where is he gone? Mr. Mukhopadhyay was appearing.
Yes, my lord, I am told that he was appearing virtually. He is there.
He isn't. He's not there.
Yes, now Mr. Mukherjee is also here, one of state is also here. Item 6. Private respondents. Actual private respondents.
Yes. দেখুন ওই মিস্টার সৌনক মুখোপাধ্যায় জয়েন করান। এই তো আছে। Yes, Mr. Mukherjee. Why are you not giving him connection?
The problem is that, my lord, the objection by the private respondent and, my lord, initially they showed that one injunction applicant has been filed, that has been refused. Thereafter, in Miss Appeal, my lord, injunction was passed. Now, my lord,
No, but injunction will not prevent them from taking electricity.
we need the police help, my lord, we will.
Yes, Mr. Mukhopadhyay.
Yes, I can record my submission. I am not objecting to new connection being granted to the petitioner. My lord. I am only on my plot being used for planting electricity poles. Way leak permission, my client is not agreeable.
Is the plot of the private respondent being used for installation?
I'm telling you. What they have shown to us, that the plot belongs to them and we need to install 2 poles, 2 PCC poles. When we went there, objection was raised. Now, my lord, we returned. Then second time, my lord, when we went there, they have produced some documents showing that this plot belongs to them. Now again we went there, this Maya Singh, now, my lord, raised objection. Now, my lord,
Maya Singh is
the
petitioner.
not Maya Singh,
Maya Singh is the petitioner.
That Bokshi, my lord. Just give me 1 minute, man. The response that is
number 6.
respondent number 6 objection. Now, my lord,
Mr. Mukhopadhyay, you are appearing for all the private respondents.
No, my lord, respondent number 6. Only respondent number 6.
Just give me 1 second, my lord.
About the others,
Others one have refused. There are 2 refusals.
7 and 8.
Respondent number 7
the
and
others are represented. Somebody representing the other. You are
But only Kalpana Bokshi. She is.
You?
I'm for the state.
Oh, you are for the state.
Kalpana Bokshi. She is the main person.
Kalpana Bokshi is represented by Mr.
Now, my lord, problem is that, kindly see that the RS DAG number 24 LR31, we don't know who it belongs to whom. We need to install 2 RCC pole. Now, my lord, if that be so, then the remedy, your lordship, subject to correction, to send before the district magistrate to ascertain, my lord.
Mr. Mukhopadhyay, kindly come to page 20 of the writ petition.
My lord. Give me 1 minute. Page 20, my lord. I'm on page 20.
There are 2 DAG numbers given there. Sorry.
Page 20, my lord, is prayers subject.
Prayers only.
My lord.
You will find RS DAG number, LR DAG number.
That's the petitioner's plot. I am not disputing. The RS DAG number 37 is the petitioner's plot that they are occupying. I don't know as to title.
If the pole is installed here, you won't have any objection then.
In petitioner's plot, no difficulty. If my lord kindly has a look, my colleague is there with a map.
My instruction is different, my lord.
My lord, you will grant me 1 minute, my lord. My lord, 1 minute only. If my lord, my colleague can hand over, Miss Chatterjee, I think she's there, my lord. If she can hand over a map of the vicinity of my clients, I'll just indicate what the difficulty we are facing.
Dhirendranath Singh, they also, my lord, raise objection.
Dhirendranath Singh.
I don't appear for any other of them.
This is my mistake. I ought to have pointed out the name of Dhirendranath Singh.
Dhirendranath Singh is not a party here.
No.
But kindly see, my lord.
Maya Singh is wife of Dhirendranath.
Yes, that is.
Dhirendranath Singh can't object.
Kindly see, due to
can't be
some
somebody
confusion.
You have missed someone else's name mixed up with someone else.
Seems to be some private dispute, my lord, between the petitioner and
No.
No.
That dispute.
If my colleague has handed over.
Mukherjee, now he will only settle. Husband and wife, Mr. Mukherjee. Be careful.
Malad, subject to Malad's kind consideration, while the map is being handed over, if I may suggest a via media, Malad, electricity connection I cannot oppose. I am an adjacent plot holder. I am not saying anything in that regard, and Malad will record my submission. But insofar as the installment of electricity poles, Malad will kindly relegate the matter to the district magistrate. He is authorized under Malad the works of licensees rules. I'm sorry.
Mr. Mukhopadhyay, if the pole can be installed in his own land, then
No
unnecessary.
difficulty. No difficulty. But I don't believe it can be. I'll just indicate why.
37
But
according to
37 and
Yes.
46. But may I just take the instruction, because in respect of these two plots, nothing has been mentioned. Only has been recorded in the instruction that objection has been raised by Kalpana Bakshi. Objection has been raised by Kalpana Bakshi. And
Mr. Mukherjee, so far as Dag number 37 is concerned, Kalpana Bakshi has no objection.
very well. I will just take the instruction that whether in RS Dag number 37 corresponding to LR 46, whether
37 and 24, Kalpana Bakshi does not have objection, is what it appears. 37 and
I have only a difficulty at 23. 23, Malad, I am objecting to any electricity bill.
23 has to be bypassed.
But only thing is that kindly see, Malad,
Yes.
residential premises is Dag number 37 LR 46. If pole can be installed in this plot, Malad, I will take that instruction, Malad.
Yes, 37 it can be done. 37 is his plot.
I will just take the instruction whether it is physically visible or not. Kindly keep it, Malad. I will take that particular instruction.
Like
is the main problem.
At the petitioner's residential premises. Full stop. Paragraph. Mr. Dasgupta, learned advocate appearing for the petitioner, submits that the petitioner seeks electricity connection at the petitioner's residential premises, but the same has not been granted by the respondent electricity authorities. You have made payment? No.
Yes, Lord, I have made
Despite payment having been made therefore. Full stop. Paragraph. Mr. Mukherjee, learned advocate appearing for the WBSEDCL authorities, submits that WBSEDCL authorities, in principle, have no difficulty in granting electricity supply to the petitioner, but they have been prevented from doing so by the private respondent. Full stop. Affidavit of service.
The affidavit of service,
Have received and
respondent numbers 7 and 8 have refused. All others have received. এটা একটু দিয়ে দেন।
একদম উপরে একটু লিখে দিন, ওটা দিন। Affidavit of service filed in court today is taken on record. Full stop. একদম উপরে লিখে দিন ওখানে যে affidavit of service এর জায়গায়। Who have received?
And all others have received. Only 7 and 8 have refused.
It is submitted by Mr. Dasgupta that while the respondent numbers 7 and 8 have refused, the other respondents have received the postal articles sent to them. Full stop. The respondent number 6 is represented by Mr. Mukhopadhyay, learned advocate. Full stop. Paragraph. Mr. Mukhopadhyay, learned advocate appearing for the respondent number 6, submits that his client has no objection if electricity is supplied to the petitioner. However, the electricity should not be supplied to the petitioner by erecting poles on lands belonging to the respondent number 6. Full stop.
But kindly mention the land number, Malad.
It has been clarified by Mr. Mukherjee that insofar as Dag number 37 and 24 are concerned, if poles are installed there, the respondent number 6 would not object to installation of pole there because the petitioner is the owner of those lands. Full stop. Paragraph. Mr. Mukherjee, learned advocate appearing for the respondent WBSEDCL authorities, seeks time to take instruction as regards the specific location where poles can be installed.
It can be inspected also.
Maybe he
Very
wants
well,
to be sure. How soon can you come back?
But only thing, my Your Lordship, recorded from the prayer it appears premises Dag number 37, LR is 46. Therefore, 37 or 46, if we install, my lord, the private respondent has no objection. My lord, we will make an inspection in presence of both the parties. Kindly
very well. As prayed for, let a fresh inspection be conducted by the respondent WBSCDCL authorities to ascertain as to whether poles can be erected in Dag number 37 and or Dag number 24.
But 24, my lord,
these are
37 and LR corresponding, LR 46.
37 is the subject plot. 24 belongs to somebody else, that is my husband. 37 belongs to me. So, Lord, either
37 corresponding to LR that number 46.
24, there'll be a problem if 24 is in.
But I do not know. If it is, if the authorities say that, no, I don't have any problem, or even I'll take instruction from the owner of Dag number 24 as to whether he has any problem or not. I'll take instruction on that ground. My Lordship may only, my Lord,
97, 24,
37, either in 37 or any public access road.
37 or any other public road not owned by either the petitioner or the private respondent. Let an inspection report to such effect be filed before this court when the matter is made returnable.
kindly give me at fortnight time.
List this matter on August 25, 2026 as prayed for.
Grateful.
Grateful.
Next. আচ্ছা লিখে দিন একটা ওখানে লিখে দিন they upon prior notice to all parties.
May I say one thing? Kindly fix a date and time from here. Otherwise,
Yes, because I don't know when the others will be available. That will be difficult.
I'll have to take that instruction. I don't know. Yes, ma'am. Let a notice be served. We'll attend. We'll try to attend. There's no difficulty.
Five minute time for the petition. My lord, straight away, my lord, kindly, my lord, takes up, my lord, page 21. This is the order of a DM, my lord, for shifting of a pole. What I am seeking is, my lord, entire, my lord, compliance of this order only, my lord. Kindly, my lord, takes up 21, my lord, 23, my lord, is the 22, my lord, starts from there, my lord, the operative portion of the order, my lord. The last line, the second last paragraph, my lord, after considering, page 22.
Page 22.
22, my lord. After considering sketch map, my lord, your lordship found. After considering sketch map submitted by the WBSCDCL and photography appears that WBSCDCL has erected a new 8-meter pole to provide NSC to Prashanto Mondol's house. The pole was erected within the boundary iron grill on vacant land owned by Hemanto Mondol without his consent. For the foregoing reasons, I direct Station Manager Chompahati Electricity Office to shift the erected electric pole outside the iron grill gate owned by Hemanto Mondol within a period of 2 weeks thereafter. After that, my lord, kindly takes up, my lord, page 24. They fixed a date, my lord, for shifting.
Yes.
Page 24 is, my lord, the date for subject is, my lord, shifting of a pole of new service connection of Prashanto Mondol at such and such Chompahati CCC.
It has not been done as yet.
Yes, my lord, what has been done is, my lord, pole has been shifted, the wires remain.
Yes, Mr. Bandopadhyay.
My lord, I have taken instruction. My lord, the pole has been shifted outside his boundary. And my lord, our main my lord have inspected the premises again, my lord, after receipt of this petition. My lord, there is no pole is my lord, running through over the my lord, the plot of the petitioner. It is my lord.
But he says the wires are remaining.
No, my lord. This is a my lord, lined allegation, my lord. There is no such hanging where a line has gone through, my lord, the common passage, and that line was there since 2006. He has purchased the property 2013.
Lordship, kindly take some, my lord.
This is my specific instruction.
Kindly, my lord, take some, my lord, the photographs I have annexed.
And the wires are not going through his over his plot of land. It is outside his boundary.
What the page number? Lordship, kindly comes to my lord, page 12. Page 12, my lord, I have annexed the photographs, my lord. But what has been done is, my lord, the condition is this. The pole is just outside the gate. The wires entirely, my lord, go through, my lord, the land of the plot of inside the iron grill, my lord, within the premise of the petitioner. Your lordship, my lord, if your lordship, my lord, sees, my lord, your lordship, what I'm proposing, my lord, to your lordship is, my lord, send, my lord, any special officer at my cost, my lord. Let there be an inspection, my lord, and a report be filed. But considering the situation, my lord, the order was passed by the and this was, my lord, passed pursuant to, my lord, a previous round of writ application, my lord. At page 16, I've annexed the order.
But the direction was only to shift the pole, not the wire.
The pole is not, my lord, as individual structure, my lord. Pole contains wires.
That was not his.
The difficulty is, my lord, but kindly sees the difficulty, my lord. The pole comes with wires. The wires cannot be.
Pole is supposed to give support to the wires. Pole is only a strut on which the wires are drawn.
My lord.
Now, the pole is in your boundary. The wire is overhead. The pole was obstructing your boundary or whatever your passage. Therefore, that was directed to be removed. And the direction which has been passed by the district magistrate is to take it out of your boundary.
Outside the boundary of the outside my
The
boundary.
wire has to remain. Then in that case, the alignment has to change.
Yes.
The alignment itself has to change. For example, suppose if there is a wire going this way.
Yes, I understand, my lord. What is falling from your lordship?
Then where will the
What is falling from your lordship, my lord? I understand, my lord. But the difficulty is, my lord, what my instruction is specific instruction that the wires continue to remain, my lord, inside the premise in a hanging state. Whereas, my lord, the initial writ petition and, my lord, the subsequent action were.
But the wires, whatever the wires were there, the wires will remain. Only the pole will shift its position so that your space within the boundary wall is
that is not obstructed.
by the pole.
That is not obstructed.
This service line is for another person, not the
Certainly, my lord.
earlier private respondent. Both of them are his brothers. Actually, they three brothers. They are quarreling within.
Kindly consider, kindly consider the scenario.
Objection is there.
Kindly consider the
previous one, Prasanto Mondal. He is also his brother. Now this line has gone through the marked common passage. This is my specific instruction, and that is the line has gone through the premises of Simonto Mondal.
For shifting of the electric line.
Yes,
has been
that was not his prayer. That was not
kindly consider the scenario. My lord, as on today, the pole just, my lord, has been shifted, my lord, outside my boundary wall. My lord, I cannot have any objection to that. What, my lord, has been done is, my lord, the wires remain. The wires keep on hanging. The wires keep on hanging. My lord, anytime, my lord, the thread that was previously, my lord, there because of electrocution, that still remains every day.
No, it's not hanging. It's
kindly
has gone.
File a report to
My lord.
My lord.
Item number 14. My lord, I am for the petition. Lord, they have no permission for install the pump.
My lord, petitioner, he is making this application, my lord, so that we may not give connection to private respondent. And his representation is there, that is to be decided. That's a prayer. That could be done. That could be done.
Between the,
has already been given to him.
the distance between this pump is 20 to 30 meter only.
Lord, I,
Decide the
on this issue, Lord, I have no instruction. My
You
lord,
take decision on their representation.
Lord, but I
Upon
don't
hearing
find
both of them.
but I don't yes, yes, yes. Yes.
My lord, kindly
yes.
record
I'm
that
sorry,
the
Lord.
connection was given to me upon payment of that statutory, my lord, bill.
They have
And
no permission.
that pump is not for the purpose of cultivation. Because I have also, my lord, peanuts business as well as
That
vegetable.
could be considered, my lord, the application.
That is my submission.
Will be considered on merits there. The petitioner is aggrieved by the non-consideration of the petitioner's representation against
I appear on behalf of the petitioner. I am led by Advocate Sanjay Mukherjee in this matter. The Lordship may kindly keeps this matter on Wednesday. Mr. Mukherjee is not fixing, kindly keeps it on Wednesday. Today and tomorrow he is not available before the Honorable High Court.
Why?
Okay. Delhi.
An accommodation is prayed for.
I'm grateful.
I am for the detail.
An accommodation is prayed for on behalf of the petitioner.
My lord, this writ petition is, my lord, for restoration of electric connection. My lord, facts of the case is that the father-in-law of the petitioner, my lord, is the owner of the plot in question. And on that land, my lord, one dwelling house of the petitioner is there. My lord, in the year of 2017, my lord, 2007, the husband of the petitioner constructed one G+1 storied building on the said plot of land, being the son of the private respondent number 5. And thereafter, in the year of 2012, the petitioner made an application for new electric connection. And on the basis of the said application, my lord, the CSC authority, my lord, has given new electric connection. But my lord, in the month of September 2025, due to some unknown reason, the meter room has been broken down. Consequently, the electric connection was disconnected. Immediately thereafter, the petitioner made an application before the distribution company limited, and thereafter the distribution company limited issued a quotation for restoration of electric connection. Accordingly, the petitioner deposited the said amount, but thereafter the distribution company limited went to give the reconnection, but due to the objection raised by the private respondent, my lord, distribution company cannot.
Yes, sir. What is the objection?
My lord, I appear on behalf of private respondent, my lord. My lord, here the petitioner is not the owner, not occupier. The husband of the petitioner is the occupier, and my lord, owner is private respondent 5 to 8. Owner, but he's
Only
5. But 319, my lord, he desired to get electricity. The owner is the father of the petitioner, grandfather-in-law of the petitioner. My lord, here, my lord, this is a joint property, but here in this case, my lord, petitioner is not the owner or occupier of the property. Occupier is the husband of.
Is not residing there.
Residing there,
Then-
but she's not owner. But his
He cannot be
ambition to
owner.
fast.
If the petitioner is residing there, then why should the petitioner not get electricity supply?
My lord, correct. But his intention, my lord, here to shifting the line, my lord, by using the property of the private respondent. There are 3 plot numbers: 321, 320, 319. All, my lord, property belongs to the private respondent here. But for that reason, my lord, since he is not owner, my lord, or occupier, without consent of the private respondent, my lord, the petitioner.
Petitioner will get electricity connection, but no right or equity will be there in favor of the petitioner because of the electricity connection. That I will clarify. But if the petitioner is in occupation of the premises, why should the petitioner not get electricity supply?
But not that his intention.
Admittedly, my lord, the
his
petitioner was
intention, my
enjoying
lord,
the electricity connection.
her intention for drawing electric connection by using the property of the private respondent. That cannot be.
The petitioner will not get any interest in the property because of the electricity connection. That will be clarified. Usually it is that the petitioner will get electricity supply. That will not create any special right or equity in favor of the petitioner.
Without using the property of the private respondent.
Without
But
using the property-
touching the property of the private respondent.
What is your instruction?
My lord, our contractors went to shift the meter board on 8th October 25, but they could not do it because of the objection, strong
Want
objection.
it to be shifted.
Again on
Meter board is required to be shifted.
it has been damaged. Earlier meter board is totally damaged in stock. There was severe storm. As per my instruction, region is storm. It is totally damaged. For that reason, it is to be shifted. It will be
Where?
shifted.
Yes. Where? Shifted where?
To a new location. That
Where
is
is that
the
new
petitioner is to say.
My lord, where the earlier board was there, my lord, just adjacent to that plot. Because of that, my lord, that portion is, my lord, that portion, one pond is situated, my lord.
No. The portion where you want the electricity supply to be shifted, is that under your occupation? No.
Yes, my lord.
The portion where you want it to be shifted, is that under your occupation?
Yes, my lord. That is also my occupation.
Yes, if it is under his occupation, it can be shifted.
No, my lord. The route was without using the property of the private respondent.
Conducted any inspection to find out which is the feasible place.
The route was different way.
My lord, our agency went to shift the meter on twice because of the objection.
Found out an alternative place where it can be shifted. Have you conducted an
There are other
inspection?
meters at that place. That is not clearly stated.
So,
If
no,
you
no,
wanna
conduct
guide-
My lord,
we
if
can make an
possible,
inspection.
earlier position, if possible,
The petitioner
We can make an inspection in presence of both the
And Mr. Mukherjee is leading him.
We requested my lord to just argue on one point, my lord, which your lordship had expressed, my lord, some doubts about. So whether, my lord, provisional application should be entertained, my lord, in such a case, where the effect, my lord, is, my lord, really, my lord, of vacating of the order. Now, my lord, my lord, make a very simple submission here. My lord, kindly, my lord, come to, my lord, I'll just show 4 provisions which your lordships would have seen anyway.
The matter was made CAV, my lord. I don't want to interrupt, but again, your lordship has reserved the judgment, my lord. Today it was kept for only showing a judgment. It was made CAV, sir. 5 দিন 6 দিন জিষ্ণুদা আর্গিউ করেছে 7 days it was argued. না আমি দেয়ার কি কিন্তু it was made CAV, only a judgment was to be shown.
He wishes to argue a point.
I can't say, but it was made CAV, my lord.
Yes, but after that it has.
But he's
brought
very
on
soft,
record.
my lord. Your lordship can.
Oh, you are also, my lord.
With me, my lord, he's very soft.
We're there, and it is not that I'm hearing it. I'm closing it on hearing him only without affording an
But
opportunity.
it was closed, my lord. The hearing was closed.
So, if it is made CAB, it cannot be brought in the.
No, I am not saying that,
Then
but
why do you make?
we thought only a judgment would be shown now. Mr. Mukherjee has come now.
No. My lord, তুমি judgment-টা কোনটা দেখবে?
জিষ্ণুদা আমাদের যেটা দেখিয়েছিল আমরা ভাবতাম ওটাই শুধু দেখানো হবে।
আমি জানি না কোনটা দিয়ে।
It was understood that only a judgment shall be shown. Only a judgment shall be cited.
My lord, notes have also been filed, my lord, I'm told.
No notes have been filed.
Notes last day, my lord, I think I.
Yes, one written note you had submitted. Yes.
Okay.
My lord, your lordship seen, my lord, section 148.
এটা কি দেয়া হয়েছে?
We have got a copy of the note.
Lord, 51 Calcutta, 52 Calcutta 560 and 92 SCC online Karnataka 61, 93 Karnataka 61, ILR 93 161. These are the 2 judgments Mr. Chaudhary referred on the last day that he would be citing it.
51 Calcutta 150.
And 92 SCC online Karnataka 278.
My lord, I'll just take 10 minutes.
Karnataka is. You don't have a copy of this written note.
Yes, we've given them
2 written notes.
Supplementary written.
Yes, 1 written notes, 1 supplementary. They are prepared both.
The written note contains a number of judgments.
Yes.
Sorry, my lord, everything has been given.
Others have already been placed. Only these 2 judgments were to be placed.
Yes.
Notice, my lord, 148A. My lord,
That is
subsection
upon
1
appeal.
and subsection.
It was not functional.
Now, my lord, if we are right in our submission, that, my lord, a caveat had been lodged. And, my lord, by reason of, my lord, some fault on the part of the Shirestedar, my lord, that caveat, my lord, was not pointed out to the learned judge. My lord, what would happen? Now, my lord, the fact of the matter is, we made an application. My lord, effect of order, my lord, whether, my lord, that is the test or something else is the test. My lord, my respectful submission is, it is not the effect of the order, but, my lord, the nature of the application, my lord, which has, my lord, resulted in the order being passed, which is, my lord, the test. Now, my lord, kindly, my lord, have a look at the application we made, my lord. Paragraph 13 of the application. If your lordship, my lord, it starts at page, my lord, 94, my lord, if I'm not mistaken. Kindly, my lord, take, my lord.
Paragraph 13.
13. At page 97. Kindly see, petitioner reserves the right to file a detailed affidavit in reply to the injunction application and oppose the same on merits after due service of all relevant documents which the petitioner is entitled to receive in compliance of Order 39, Rule 3A and 3B CPC. And kindly see the prayer, recall and vacate the ad interim order of injunction so and so on the ground that the same has been passed in flagrant violation of the statutory mandate of section 148.
and without notice to the petitioner, despite its duly registered caveat number 1897 of 2020. This is the only ground. Merits were not entered into at all. Now, my lord, what is important, my lord, is, my lord, your lordship's already seen 90 Calcutta Weekly Notes, which is a division bench judgment, which says, my lord, that this is, my lord, something, my lord, without jurisdiction. Similarly, my lord, another division bench judgment, which came directly from the Order 39 Rule 1 and 2. My lord, there was no application made for recalling. That's, my lord, the judgment, my lord, the bench presided over by Justice Shobhoshachi Bhattacharya, my lord, who said such an order is completely without jurisdiction. Now, my lord, kindly have a look at Order 43 and, my lord, the, my lord, relevant provisions. My lord, kindly see, my lord, Order 43, Rule 1 R, my lord. An appeal shall lie from the following orders under the provisions of section 104, namely, kindly see, my lord, R, an order under rules 1 and 2, rule 2A, rule 4, or rule 10 of order 39. Now, my lord, kindly have a 1 and 2, it doesn't come in, 2A also it doesn't. Kindly have a look at rule 4. My lord, whether this application, my lord, can be said to be, my lord, under rule 4. Any order, I'm sorry, my lord, any order for an injunction may be discharged or varied or set aside by the court on application made thereto by any party, kindly mark the words, dissatisfied with the order. So, my lord, I have to be dissatisfied with the, my lord, prima facie, my lord, observations, findings, my lord, made in that order. It is dissatisfied with the order. So, my lord, it has to go, my lord, to the merits of the case. And, my lord, the two provisos which are there, my lord, relate to, my lord, false or misleading statement in relation to a material particular. And, my lord, the second, my lord, is, my lord, where, my lord, there are, my lord, change of circumstances. My lord, these are, my lord, the two provisos, my lord, to this. So, my lord, this is, my lord, not, my lord, an Order 39 Rule 4, my lord, application. Now, my lord, I am supported in this contention, my lord, by, my lord, an earlier order, my lord, passed, my lord, in this matter. My lord, 1st April 2026, your lordship's order, when your lordship sent us back, your lordship has, my lord, clearly noticed, my lord, that this is, my lord, a section 151. My lord, at page 200, your lordship will find that. Kindly come straight away, my lord, to, my lord, page 200, kindly come to para 4. My lord, this is the submission. My lord, it refers to such an application as one under section 151. Then, my lord, kindly come to my lord, paragraph
10, that being an application for
kindly
recalling.
come to para 10, my lord. Kindly have a look, my lord. That being so, the application for recalling of the order dated February that has already been filed before the learned trial court must be heard forthwith. Accordingly, the learned trial court is requested to take up the application for recalling that had been filed before it on February 27, so and so. Now, Miller, kindly come to Paragraph 15 also, I'm not mistaken, paragraph 15. In case the learned trial court is satisfied that grounds have been made out for recalling of the order and caveat had indeed been lodged in accordance with law, then the learned trial court shall take up the application for injunction and hear the same at least for examining the question of passing ad interim order in the presence of the defendant to the suit, that is the petitioners immediately. Now, my lord, this was, my lord, the position. Now, kindly see, my lord, what happens. My lord, I have not, my lord, invoked Order 39 Rule 4. I say, my lord, it's a 151. Now, my lord, the case of procedural impropriety, because an Order 39 Rule 1 and 2 cannot be taken up, my lord, if there is a caveat lodged without hearing me. My lord, this is so, my lord, there is no consideration, my lord, of whether, my lord, an Order 39 Rule 1 and 2, my lord, matters being heard on merits. Then, my lord, your lordship would, my lord, find that, my lord, if that is the case, my lord, then, my lord, there is no question, my lord, of, my lord, this being treated, my lord, as something, my lord, which is requiring the court, my lord, to exercise its discretion, my lord, under Order 39 Rule 4. It's a mandate. There's no other, my lord, option. My lord, Order 39 Rule 4 itself provides, my lord, for a mandate in the first proviso, that if there's suppression, then this is what happens. Because then, my lord, the adjudication on merits, my lord, has been made on the basis of false statements or, my lord, suppression. Dissatisfied, my lord, means, my lord, that there has been, my lord, I am dissatisfied with the contents of the order insofar as adjudicates, my lord, on prima facie view, my lord, on the merits, or, my lord, there is a wrong exercise of discretion. It is not, my lord, a statutory, my lord, infraction which has occurred, my lord, at the time of taking up the application, my lord, for Order 39 Rule 1 and 2. Because your lordship's aware, my lord, 148A is, my lord, for the protection of the caveator. My lord, is the duty of the court, my lord, which, my lord, to, my lord, hear, my lord, the caveator before taking up Order 39 Rule 1 and 2. So, my lord, this is, my lord, the position. So, my lord, in my respectful submission, my lord, there is, my lord, really, my lord, no scope, my lord, for, my lord, an appeal, my lord, to have been preferred. জ্যোতির্ময়টা দেখিয়ে দিচ্ছি। My lord, কোনটা দেখাচ্ছি? Yes, now, my lord, kindly have a look at JM Financials case, my lord. I just want to show, my lord, what, my lord, is, my lord, really, my lord, the, my lord, order, my lord, which, my lord, would rule, my lord, how, my lord, one is to determine, my lord, what the application is. My lord, there is, my lord, the judgment, my lord, of this court. My lord, JM Financial.
It has been shown.
We relied on this. My lord, which is why I want to rely on, my lord, my lord, my lord, paragraph, my lord. Kindly come to, my lord, I had, my lord, taken the point my learned friend had taken.
idea চলে যে আপনাকে আনবে
kindly have a look at paragraph 12, my lord. My lord, the impugned order, my lord, page 7, my lord, of the impugned order was passed on an application captioned as 1 under section 151. The question that falls for consideration in the civil revision application is whether this application is maintainable or not. Section 151 of the code is an enabling provision by which the court is vested with inherent powers to administer substantial justice. It is well settled that inherent powers under section 151 of the code can be exercised in cases, and kindly mark this, where there is no express provision in that code in that regard. Inherent powers also cannot be exercised in cases where there is an express prohibition in the court with regard to the claim of a party. Order 39 Rule 1 lays down cases in which 2 enables from committing breach, therefore powers under section 151 cannot be exercised in cases falling under so and so. It is well settled that in cases not covered by the provisions of so and so, court can pass an order. The and the same is required for the interest. Mr. Banerjee would contend that the order of injunction passed by the learned judge was under 151, as the relief sought for by the opposite party number 1 are not covered under order 39 Rule 1. On the other hand, so and so contends that relief sought for are squarely covered. Now kindly mark this, para 15. After going through the averments made in the application under section 151 and the reliefs claim, I placed, my lord, para 13, not going into merits. Relief is, my lord, of, my lord, one of, my lord, it's a nature of a procedural review. The court finds that the opposite party number 1 prayed for an order of injunction in order to prevent alienation of the property which is a subject matter of dispute in the suit and of from causing injury to the property in dispute in the suit, and to restrain the defendant from committing a breach. To my mind, to the mind of this court, the nature of reliefs claimed by plaintiff opposite party number 1 hereinafter falls under within the scope of so and so. Then, my lord, order 43, my lord, is referred to. Then, my lord, Sukhendu Maiti's case, my lord, is, my lord, referred to Banwari Lal Jalan and para 20. In the light of the proposition of law laid down in the said reports, this court holds that for deciding as to whether the order impugned is an appellable one, the court should look into the, kindly mark this, nature of the relief sought for and the order passed thereon, rather than the form of the application. So
This is exactly what I also said, because the relief ultimately will be vacating the order of injunction.
No, that's the relief which is granted.
Yes, so nature of the relief.
No,
Mr.
nature of
Mukherjee-
relief is what I have prayed for non-compliance of, my lord, 148.
That is, Mr. Mukherjee, the reason for which the interim order can be vacated. The relief is vacation of the interim order. The reason for vacating the interim order is non-compliance with caveat. It may be several other
If your
reasons.
lordship rejects my argument that, my lord, being dissatisfied would mean, my lord, that non-compliance of 148A covers that, that's a different issue. But, my lord, if
Because,
I'm
Order 39 Rule 4 does not enlist or enumerate the reasons wherefore Order 39 Rule 4 can be applied. An application under Order 39 Rule 4 can be made. There are 2 provisos which say specifically that these will form a part of an Order 39 Rule 4 application, but that is not exhaustive. It is
No.
not only in those.
So I'm requesting your lordship's, my lord, to interpret dissatisfied with the order. It has to be an issue on merits.
Mr. Mukherjee, one way of looking at this expression dissatisfaction would be that I'm not, the order is there of injunction only. Now again, I'm dissatisfied with the injunction. Suppose the caveat was not taken note of and injunction was not issued. Then there would have been no dissatisfaction with the order.
No.
Therefore, the ultimate pinch.
No, it would not have been any dissatisfaction. My lord, with the greatest of respect, there would be no cause for me, my lord, to complain.
Yes, because there is no dissatisfaction with the order.
No, my lord, dissatisfaction has to be with the order, the merits of it. Because Order 39 Rule 4, my lord, always deals with merits. Always deals with merits. My lord, that's what I'm requesting, my lord.
Act of the plaintiff. All prejudice to me.
Because, my lord, it's a failure on the part of, my lord, the court to comply with, my lord, a mandatory provision. I am not asking, my lord, for, my lord, the adjudication process, my lord, that there was, my lord, I find an error. It's not, my lord, in that sense, my lord, being dissatisfied, my lord, with the order. Now, my lord, if I had come directly, my lord, without filing that application, for which there is no express provision according to me, my lord, because I'm not going into the merits, then, my lord, one could have understood that I come directly from the Order 39 Rule 1 and 2. Because the order I'm challenging is the one which has been passed under Order 39 Rules 1 and 2. But I have gone and said, look, the duty cast on the court has not been discharged to my prejudice. Because it's really in the nature of a procedural review. Where, my lord, mostly in the cases of tribunals, your lordships have that, where, my lord, without, my lord, hearing me, my lord, an order is passed. There's no power to review. But, my lord, it's a procedural review because everybody is entitled to be heard, my lord, before, my lord, any adverse order is passed. It's not the order. A order might have been fully justified. But I had the right, my lord, to be, my lord, heard. My lord, that's the distinction, my lord, my lord, draw here between an Order 39 Rule 4 and the application, my lord, that I make for, my lord, a fault or, my lord, a mistake, my lord, on the part of the court. Because here Sharistada referred to another caveat which didn't cover the property. It's a mistake on the part of the court, my lord, which is why I have come to have that mistake rectified. It's not that I'm dissatisfied with, my lord, the contents of the order on merits. My lord, this is, my lord, how, my lord, my lord, with the greatest of respect. So, my lord, your lordship's right. Effect might be the same, but kindly look at the relief I asked for without an adjudication on merits.
But here the learned court has gone ahead and said that the caveat was not properly lodged. That is
No, that we've cited, my lord, 90 CW and, my lord.
We showed these civil court rules also.
And civil court rules had also been shown, my lord, that, my lord, if I don't sign, my lord, defendant doesn't sign, defendant's advocate doesn't sign. Once it's lodged and is on the register, court should, my lord. These are all technical issues.
Proof of delivery, lodging is shown. That's not possible.
And, my lord, this proof of delivery, if your lordship looks at one, my lord, there are two duties cast. My lord, one is, my lord, on the court. The other is on the party. My lord, my lord, 148A,
Yes.
1 and 3 relate to duty of court. 148A, 2 and 4 relate to duty on party. So, my lord, if the duty of either one, my lord, in the other case, suppose, my lord, it would have been, if I may use the colloquial expression, my lord, double whammy. I am not, my lord, questioning, my lord, the bona fides of, my lord, the other party. He says he's not received it. I had proof of, my lord, dispatch, but I didn't have proof of delivery. And that's a step to be taken after lodgement of the caveat.
So,
My lord, and,
that's
my
the
lord,
mistake.
and the finding in the order, my lord, is totally wrong. That, my lord, I have to give proof of delivery and then only is, my lord, a lodgement. My lord, kindly have a look at section 148A2. It's after lodgement.
After lodging shall serve
Correct.
notice.
My lord, that's, my lord, the, my lord, provision. So therefore, my lord, that really, my lord, and, my lord, the form, my lord, and the, so, my lord, if I had titled it Order 39 Rule 4, but, my lord, I'm only complaining of this, then it would, my lord, your lordships would, my lord, look at the contents and the prayer and say, no, in reality, it's 151. And vice versa. Here, my lord, in this particular case, an injunction was sought for, but, my lord, it was titled as 151. Court said, I won't look at the form. I will look at the contents and the
Substance of a
relief.
form.
Yes, substantive form, my lord. That's what we are before your lordship. This court has already observed that reliefs claim fall within so-and-so authority of the court to pass so-and-so. This court therefore holds that the impugned order was passed in so-and-so. Therefore, my lord, it was held, my lord, that the revisional application, my lord, was not, my lord, maintainable.
So the note se refer kara that Kerala.
Kerala, no, Rajesh Kumar Khan. Is this referred to in the note?
No.
Kerala.
Either paragraph 7.
Supreme Court. My lord, there was another case, but, my lord, my learned friend is objecting to, my lord, me not addressing. Nobody is listening to that objection. My lord, our high, my lord, after holding, my lord, that an appeal was also, my lord, maintained. sake, my lord, it doesn't take away, my lord, the constitutional remedy. And remedy bar, the lordships, my lord, are fully aware of. My lord, Supreme Court is getting stricter and stricter on that. Rajesh Kumar. So this was, my lord, peanut butter that was page 15 on
Page 15.
Yes. My lord, yeah, my lord, it was, my lord, appealable as well.
Yes, but later on this has been
My lord, diluted, my lord, there is, my lord, even today.
Virudhnagar and
Correct. My lord, even today, my lord, there is no absolute bar.
no absolute bar they can't be because of the plenary nature of the power.
Correct.
But then
That's why I
legislative
was
intent.
hesitant to cite this because there's much water has flown thereafter. But my lord, my respectful submission is it doesn't fall under any of my lord order 39 rule 1, 2, 2A, 4 and 10.
So there is no. Therefore, according to you, since it is not appealable, in any case,
Correct.
it has to be
Correct.
revised.
Correct. That's my principal submission, my lord, before your lordship. Because this is a, my
So,
lord,
Mr. Mukherjee, according to you, an application under Order 39, Rule 4, seeking setting aside or recalling of an order of injunction could not have been made only on the ground of not taking cognizance of a caveat lodged.
correct, my lord. I'll say this, and why I say this, because my lord, it's in the nature of a procedural review. My lord, order 39 rule 4, my lord, doesn't deal with review at all. My lord, it's in the nature of a procedural review, my lord, which we've handed up. So, my lord, I am not looking at the order and saying I'm dissatisfied for ABC reasons.
স্যার আমি অ্যাপ্লিকেশন ফাইলই করবো না, আমি জাস্ট পয়েন্ট আউট করলাম প্লিজ অফ ফল্ট।
My lord, one other thing is also important. Suppose, my lord, I had not filed an application. My lord, I had requested the court that look, this is what you've done, your record show my caveat is there. And my lord, the learned judge, my lord, the trial court, my lord, refuses, my lord. I would have come upon revision. Order 39 rule 4, my lord, requires, my lord, an application. Here there is no requirement. My lord, I made it very clear. I'm not going into the merits. This is what you've done. My lord, an act of court, my lord, cannot, my lord, prejudice a litigant. I'm just pointing that out.
Point of
My lord, kindly, if I may just give, my lord, another example. My lord, there have been cases, my lord, quite often when, my lord, leave granted, my lord, by court under clause 12 of the letters patent, my lord, has not been endorsed on the fiat. My lord, I may mention that this has not happened. Court corrects that error. It is, my lord, that kind of a matter, my lord, which is, it's not being agreed. That order was passed. But, my lord, it has not been recorded in the fiat. So there is, my lord, no record of it other than the minutes. Because earlier day, my lord, there used to be a minute book, my lord, where orders were minuted. And it's not there. I can point out to court. I'm speaking to the minutes. Please correct this out. If the court refuses, my lord, then, my lord, of course, my lord, in the original side, my lord, we court, my lord, inherent jurisdiction, we can make an application. Still, my lord, is no, my lord, specific power given in the rules or, my lord, in, my lord, any provision of the Code of Civil Procedure to correct this. Similarly, my lord, with, my lord, regard to, my lord, 148A, my lord, mandate on the court. And your lordship will find, my lord, that, my lord, it is, my lord, clearly, my lord, a jurisdictional error. And that is primarily, my lord, what the court is concerned with, my lord, in revisions. And that's how the power of superintendents, my lord, is. I'm not saying that in some cases, my lord, a jurisdictional error cannot be, my lord, a ground for an appeal. I'm not putting my case that high. My lord, here, my lord, all that I've done is, look, I had a caveat which had been lodged, which was on record. I'm not going into the merits. Please rehear the application on notice. You recall, kindly recall. But I'm not dissatisfied in that sense. The 39 Rule 4, Miller, Lordship will find, Miller, it relates to, Miller, the merits of an adjudication at the interlocutory stage. Because first is dissatisfied with the order. Second, Miller, proviso. Miller also indicates that its merits because an prima facie adjudication or Miller, a preliminary Miller finding has been arrived at without disclosure of all facts. And Miller, third, is a situation where I was hurt, but there are change in facts subsequently, which is causing hardship to me. So, Miller, it has to do, Miller, with the merits of the matter. Miller, that's Miller, my submission.
There is a function of appeal that the court will not clarify.
On time.
Sir, I'm answering.
Miller, may I have your lordship?
একটা মামলা করতে করতে একজন জজ হয়ে গেল পার্থপ্রতিম রায় Lord, if I have understood it correctly, Lord, only one additional point has been argued by Mr. Mukherjee, Lord, that the application was not dealing with the merit of the order. Now, with greatest of respect, when he says that his client was not dissatisfied with the order, the question comes, if you are not dissatisfied with an order, if an order is not causing any prejudice to you, then why would you come to court and say that this has been done, I have been wronged in this? Lord, we can use any term. When we come to court, we can, Lord, make any kind of argument. But the question is, in substance, what is to be done and what ought to have been done, what could have been done by the court. Not rightly, wrongly, court has exercised its jurisdiction. They are saying without jurisdiction wrongly, we are saying rightly, wrongly, whatever it is, this is not the forum to adjudicate that. And it is their rejection and the order, my lord, will kindly consider this, that it is not only the rejection of the application. The order extends the interim order. I could have understood that the interim order was made up to X date. In between, the rejection has been done. The court, at the same breath, passes two orders, gives reasons, supplies reasons, rightly, wrongly, as per the wisdom of the learned judge, Lord, he supplies reasons, saying that no, whatever I have passed, I have rightly passed, I am extending the interim order. So he not only refuses their claim, but he also stuck to the point where he has passed the interim order. So he was of the firm belief that he had jurisdiction, he could pass the interim order, that's why he has extended it. So today, by saying that I did not argue on merit, unless the order was causing hardship to them, they would not have gone there. They would not have gone there. If the order, Lord, since everything is being repeated at the cost of being reprimanded, at the risk of being reprimanded, Lord, I also wish to repeat only one sentence. If this was allowed, would you have accepted my revision application? You would not have. You would have relegated me to appeal because of Order 43. There is an efficacious remedy, I would say more efficacious than High Court. But the plaintiff is coming and knocking the door of your lordship's court only on the ground that no, the court should entertain. Now, kindly considers one aspect. Today, I suffer an interim order in a suit. I go there, I request the court to make a modification of the interim order. Look, this will not prejudice them. I am asking for a water connection or electricity connection. Would that not amount to modification of the injunction by filing 151? Would I be able to come up in 227? Kali considers not this. There is an injunction on an immovable property. I say that I am not making construction, allow me to enjoy electricity on that property. They will not be prejudiced. Under 151. The court would have to go into the injunction order, modify it. Like if it is modified, partially allows my prayer. Yes, you can have water connection. There's an order of status quo granted. Defendant comes up and says, I am in the property of portion, allow me to have water connection. The court would have to modify the order. But kindly considers this. Today, whatever be the reason, the effect is you vacate the injunction. And what about para 13? What does para 13 refers? Does it say that you don't have to look into the papers, you don't have to go into the merit? He says, allow me to use an affidavit. That he can always do now. It's an ad interim order. He can go there, go back and file an affidavit and get the injunction heard. If he has a case, he can always do that. That door is not closed for him. But kindly just
about the observation of the court that caveat was not properly lodged.
But that's an observation on the merit of that issue.
Yes.
That has to be agitated before the appellate forum.
No. What is your answer to that?
But I would say the learned Singh, Mr. Mukherjee has said that it's not a perverse finding. He has given his reasons.
Because of the new amendment.
Exactly, because of the new amendment.
Can be a wrong interpretation.
But kindly appreciate it. It's an erroneous order. Let us take that it's an erroneous order. All reasons supplied are wrong. Would that not allow them to jump up forum and come to your lordships? Let us take it that everything written is wrong. All wrong reasons, all wrong interpretation. A judge, my lord, with greatest of respect, has a right to pass a wrong order. And that's also binding, as we have learned from my lords. That's also binding until challenged. So he has passed a wrong order. Why do you choose a wrong forum to adjudicate to correct a wrong order? So just take a one-page judgment. Justice Sanjeev Banerjee, one-page judgment. But I think we have been able to at least succeed to that extent that one person doing the matter has been elevated. Seniors after seniors are coming and opposing these non-entity. We are non-entities in front of them.
That is your way of looking at the matter. The court may not agree.
Kindly have a look at this. Kindly see what the court says. The petitioner is a defendant in a suit relating to an immovable property and applied for modification of subsisting injunction by way of an application filed under 151. The order of injunction has been challenged in an appeal which is pending. The present petition is directed against the order dismissing the application under 151. Notwithstanding how the relevant application may have been instituted, the substance of such application was for modification of a subsisting order of injunction or an application in the nature of Order 13 and Rule 4. The resultant order will be, mark this, appellable, and this extraordinary jurisdiction should not have been invoked by the petitioner ahead of the efficacious alternative remedy. What we have been arguing for the last 7-8 days, one paragraph, my Lord Justice Banerjee has said. Okay, take this, another one.
Procedural irregularity.
What about procedural irregularity? As you Lord said, just post me a question, Lord. What about the explanation under 140? What has been given? Para 8. Kindly come to para 8.
7
Take from para 7. Kindly got that. The plaintiff filed an application under 151 seeking extension. Para 7, Lord, I'm sorry. seeking extension of the interim order passed by the division bench. The defendant filed their objection to the application. The learned trial court, however, refused to extend the interim order and recorded its reasons for the refusal. The order of the trial court is dated so and so. The plaintiff preferred revisional application from the order being CO number so and so. The impugned order dated so and so, which is the subject matter of the present application, was passed. In the said civil divisional application filed by the plaintiff, the defendant seek recalling of the order. The grounds taken for recalling of the order is that the order was disposed of without giving an opportunity to the defendant to present their case. Like the present one, no opportunity. Learned counsel appearing for the applicant defendant also argues that the order dated so and so passed by the learned trial court, which was the subject matter of the revisional application filed by the plaintiff, was passed under 151 CPC and is not an appellable order. Counsel submits that the said order was passed on merits and in terms of the direction of the division bench contained in the order is so and so. Counsel submits that there is a specific provision for appeal against such order in the Bengal Agra Assam Civil Codes Act 1887. It is submitted that the plaintiff withheld crucial facts from this court and are hence guilty of suppression of facts. Counsel also submits that the plaintiffs have chosen not to take any steps for hearing of the application order 13 rule 1 and 2, which is still pending. Now, then can I take 9? Learned counsel appearing for the parties, plaintiffs who were the revisionists before the court, obtained the order dated so and so, submits that the order passed by the Uluberia Court Trial Court dated so and so was on an application under 151 and is therefore not an appellable order. Counsel submits that there was no bar on the plaintiff to file an application under 227 of the Constitution. The gist of the argument made on behalf of the plaintiff is that the order of the learned trial court dated so and so is not an appellable order under Order 43 Rule 1 CPC, and the plaintiffs were therefore constrained to file the civil revisional application. Then take para 11. The answer the second question first. The plaintiff had previously preferred an appeal from the order of the learned court refusing to give interim relief to the plaintiff in the plaintiff's application 39 1 and 2. In the second round, however, plaintiff chose to file a civil revisional application 227 instead of following the earlier route taken by the plaintiff in an appeal under Order 43 Rule 1. It is also correct that at the time of moving the revisional application, an appeal court available to the plaintiff. Further, although the plaintiff says that the applicant, but can I take 14? Can I come to 14? With regard 14 and 15. With regard to the question as to whether the order passed by the trial court dated so and so is an appellable order, it is well settled that an erroneous nomenclature or filing an application under a wrong provision would not disentitle a party to relief sought for. Several decisions of the Calcutta High Court have been conclusively settled that even an application filed under 151 would be an appellable order under Order 43 Rule 1 CPC, subject to the application being read as a whole and not only the caption and heading of the application. Coordinable judgments have been quoted. 2000 volume 1 is Justice Bhaskar Bhattacharya's and the other one, Lord, 2009, we are carrying it. Justice Partha Saka Datta's judgment. Therefore, even though the order passed by the learned court on 23rd September 2022 was passed in an application under 151, it is a detailed order touching upon the merits of the case. The order raises issues affecting vital rights of the plaintiff and the defendant. The substance of the order refusing to extend the interim order so and so effect is to file an Order 13 1 and 2 and their appellable order. Lord, whatever be the nomenclature, your lordships would only look into the effect. Mr. Mukherjee has relied on the judgment which I cited. Para 15, Mr. Mukherjee referred. Kindly have a look at para 15, only one line, what Justice Bhattacharya has said.
Yes.
No, para 15, na? Para 15 ki? Haan.
To the mind of this court.
Yes, where the court says, yes, para 20, I'm sorry, para 20. In the light of the proposition of law laid down in the said reports, this court holds that for deciding as to whether the order impugned is an appellable one, the court should look into the nature of the relief sought. Now, relief sought, what is the relief sought? That is undisputed. Recall, vacate the interim order dated injunction dated so and so, page 97 of your lordship's brief, against the defendant on the ground there has been flagrant violation of the so and so without note at the granted stay. So you prayed for recall. If it had been allowed, that would have been an appellable order. If it is refused, that's also an appealable order. Order 43. And Mr. Mukherjee was rightly saying, before 76 amendment, before introduction of the provisos, there was 39(4). That has been taken, Justice Bhattacharya. Lord, the provisos create some exceptions under which you can come, but as has fallen from my lords, the main section, it says varied, vacated. So you prayed for vacating. You have an efficacious remedy. You should go there and agitate all your points. We succeed, we lose, we lose. But do not jump a forum. Do not allow them to jump a forum and come to court. And where we also lose a forum. But these are my submissions. No, there is nothing. These are on question of law. I have been. No, my lord, kindly. Yes. Oh, dhile.
That CO pertinent to it came from an order in which the plaintiff had applied for modification.
Which one are you?
The first one, CO 257 or 2016. If I may indicate the first paragraph, your lordship, it says applied for modification of a subsisting injunction under section 151. That is not the issue under question in this current CO. We are losing sight of the fact that the only ground under which we had proceeded under section 151 was violation of the duty of the court in not taking note of the validly lodged caveat. We are not on the merits, we are not on the contents of the injunction order at all. Being dissatisfied, not being dissatisfied is an entirely different cause of action for the defendant. We are only on the limited scope here, that duty of the court to take notice of the caveat which was validly lodged, and we have also indicated 148A 1 and 2 read together. Track report was not to be given at the time of filing of the caveat. We are only on the limited scope here.
That is merit.
And also, if I may indicate one paragraph from the second judgment that they have cited.
Modification is the 39 that is the reason.
One paragraph from the last judgment, your lordship, they have said it has been held that in their modification of the subsisting order of injunction was in the nature of Order 39 Rule 4. That is not the subject matter in this current CO. Also, if I may kindly indicate one paragraph from the second judgment they have cited, your lordship, para 12, page 6. It has been recorded, although the plaintiffs say that the appellants / defendants did not file any caveat and the plaintiffs were entitled, is a lordship there at page 6, para 12. Although the plaintiffs say that applicants / defendants did not file any caveat and the plaintiffs were entitled to move ex parte. Your lordship, in this case, in the present, we have validly lodged a caveat. The Sharestada did not take note of that. The Sharestada took note of a different caveat that was lodged in respect of a different dark number. There was a subsequent caveat that was in respect of the dark number in question. This was a complete failure of the duty of the court. We are not on the contents of the injunction order at all. We are simply on the question of whether it was the duty of the court to take note. Since the court did not take note of it and it was a failure on the part of the duty of the court, that is why it is without jurisdiction and flagrant error. Patent illegality is on this limited question.
Both the cases do not come up from a court error. This is on
Both
merit.
these judgments, they do not come up from the court error. They both were on merit, and we are not on merits, your lordship.
By vacating, we can go ahead to
Yeah,
the injunction hearing.
On vacation of the, if at all the order is vacated, we can go before the trial court and move on merit. We can complete. That is what we wish to do.
If it is vacated. If it is vacated.
Merits, your lordship.
If it is vacated.
This is a very limited scope.
Very good.
The procedural error, your lordship. This is a procedural error that the court did not take off the caveat.
Closing.
Finally.
Written format error or a supplementary?
Your lordship, if liberty may be granted to give a written note of
No, my lord, there are two. Look, there are two notes, my lord. I don't think anything is. She has said that, my lord. Again, tomorrow somebody will come and again mention. Take that.
Only one thing, my lord. Before my lord was original said kindly because this is item number 43.
45.
My lord, 45. My lord, I have indicated if my lord doesn't take it, that bank matter where my lord, I was carrying the money, my lord, with myself. My lord said Mr. Sharon Chatterjee on the other side. My lord directed him to take instructions.
He's
My lord,
there.
he is there. My lord, tomorrow is the auction date. My lord, today my lord is taking original side. If tomorrow it can be kept as to be mentioned tomorrow morning.
You mentioned the দিয়ে দেবেন. Put him on notice. Please bring him.
45. My lord, I can
During the day,
verbally tell him, my lord.
if during the day he is here, please bring him. I'll indicate it to him.
Very good. 45.
Because he should not be taken by surprise.
Absolutely.
Bring him here, I'll tell him.
Item number 1, I appear for the applicant. Lordship, this
Oh,
innocuous prayer for expunging the name of the
yes.
respondent.
ভুল এসছে এখানে তো আর নন কন্টেনশাস তো কোথা থেকে এলো কার নাম এখানে ঢুকিয়ে দিয়েছে এস পাল লিখুন there is a this matter has been mentioned for correction
My lord, I am appearing for the petitioner, my lord. This is the unregistered will, my lord, made on 22nd April 2005. And after that, my lord, the all, my lord, assets and liabilities has already been annexed with these petitions. And also, my lord, the affidavit of only citations. All are complete. Online.
My lord, I'm praying for issuance of general citation and special citation, as said in the prayer A and B. General citation, there are 6 legal errors. Out of them, one of them has not given the consent. So for that, I'm praying for a general citation to be issued. And in terms of prayer C, the ad valorem duty be postponed. My lord, Shashi Gupta, if you come to para 5, Roman number 5, Shashi Gupta, she has not given the consent. All others have given their consent.
Item number 4. Item number 5.
On behalf of the petitioner, all the formalities complied with, kindly grant me the probate application.
Lord, I am for the petitioner, my lord. Pursuant to my lord, order dated 25th of February 2025, my lord, citations were issued. My lord, no caveat has been filed till date, my lord. My lord, if my lord may kindly take my lord the application once, my lord, the probate application once. Probate application once. My lord, the deceased, my lord, published his last will and testament on March 19, 2021. My lord, the deceased died on my lord, April 20, 2021. If my lord may kindly take para 8, my lord, once, my lord, the years of the deceased. My lord, one son and two daughters. My lord, both my lord, the address are not known to the my lord, the executrix. My lord, the executrix is the my lord, the beneficiary under the will. My lord, executrix is my lord, the beneficiary under the will. My lord, thereafter, my lord, we my lord, trade for my lord, are not known to me, my lord. My lord, that is why, my lord, we, my lord, preferred, my lord, the order dated 25th of February 2025, my lord, directing me to, my lord, issue citation on, my lord, both the, my lord, the legal heirs, my lord, of the, my lord, the deceased, my lord, who ought to have, my lord, my lord, who ought to have, my lord, inherited, my lord, the property of the deceased, my lord. My lord, the affidavit of, my lord, the compliance, the affidavit of service dated 22nd of February 2025, Lord, we have published Lord, the citation in two Lord, daily newspapers. One is Lord, the Telegraph and another is Lord, Anandabajar Potrika on Lord, 23rd of March 2025. Lord, the affidavit, Lord, the asset is Lord, dated Lord, 29th of February 2024. Lord, the asset of Lord, the deceased Lord, aggregates Lord, 70 lakhs 8,711, Milord. And Milord, the affidavit, Milord, of the attesting witnesses is also Milord there. Milord, 15th of March 2024, Milord, both dated 15th of March 2024. Milord. I'll be humbly praying, Milord, for grant of probate. No, Milord. I Milord, brought the death certificate of Milord, the deceased and Milord, the wife. Father and mother Milord, I could not. The father and mother Milord, both predeceased Milord, the deceased. Father and mother of the deceased Milord, both predeceased Milord, the deceased. Milord, he was aged Milord 82 years of age. 82. From Milord, the death certificate at page 12. And my lord, page 17 is my lord, the death certificate of my lord, the wife of the deceased. My lord, due to my lord, the language of the will, my lord, is that my lord, the children did not take care of my lord, the deceased. That is my lord, the deprivation. Perhaps my lord,
The deceased died on 11th November 2021. Bill came up. It was dated 5th November 2021, which is at page 10 of the application. Mother of the deceased predeceased much earlier than of the deceased, leaving behind the father and the brother, as he was a bachelor. My lord, he has assets in Darbhanga along with in West Bengal. That's why an application was made for special general citation. And that was allowed by an order dated 27th of March 2025, and subsequently publications was made in two newspapers, one in Times of India and the other in Sunmark. And the publications came up on 10th April 2025 and 11th April 2025, respectively. That was completed, and all formalities thereafter has also been completed. Now there has been one subsequently. One application was only made before for general citation, which is GA number 2, which was numbered as GA number 2. Only one application. Now this GA number 1, there is no existence of it. It's by mistake. As per the record of the case itself, it's absolutely clear. certificate is at page 9, my lord. Page 10, my lord. 10. The next page of the death certificate. Testing witness is my lord separate. Sumon Kumar Jha was the attesting witness. There were two witnesses. He, along with Tribhuvan Kumar Chopal, they were the two witnesses. One.
For my application for letters to administration. What test? This is being Lady my lord, executed her will on 11th of December 2006, my lord. And she died on 21st December 2018, my lord. And in the will, my lord, she named her only son as the executor, my lord. Subsequently, the executor died. Died on 3rd of May 2021, my lord. One of the beneficiaries, my lord, named the will has applied for letters to administration, my lord. but deceased left his only son, subsequently died on 3rd May 2021, and son has his widow and one son. And deceased has two grandsons out of her daughter who predeceased the deceased my lord. One of the grandsons, my lord, has come before this honorable court for grant of letters of administration, my lord. And all of them have given consent separately, my lord, and the affidavit assets have been filed. And my affidavit, my lord, consenting affidavit we have filed. And my affidavit Tapas Kumar Dotto, who has affirmed this affidavit regarding the execution will, my lord, we have filed. Tapas Kumar Dotto executed the affidavit, affirmed the affidavit, my lord, on 12th day of April 2024, my lord.
Lordship, this is an application for grant of probate of the last will and testament dated 24th of March 2021 of the deceased. The will is at page 11, Your Lordship. Lordship, the deceased passed away on 10th of June 2021. The death certificate is at page 10, Your Lordship. Lordship, the will, which is at page 11, is it is attested by two witnesses. The affidavits of the attesting witnesses annexed with the application, Your Lordship. Lordship, there are three heirs of the deceased, and the consent affidavits of all the three heirs are also annexed with the application. Lordship, the affidavit of assets, the net total is 4,97,66,241, which is evident from the affidavit of assets, also annexed with the application. Part of the application. Yes, Your Lordship. He's one of the heirs. Lordship. Yes, yes.
Gauri Bhumi published her last will and died after policy. Applied third citation.
The name of one of the heirs has been wrongly mentioned in the will. No? Your affidavit of consent says so. Please check your affidavit of consent. I'm making it not this week. Come back next week. Please check the affidavit of consent of Priyobroto Bhaumik and match it with the will. There is a discrepancy in the name. Not this week. Next.
This matter pertains to a letter of administration without will, my lord. The deceased died in 1994. The petitioner before your lordship is the only letter of expired long ago. XP deceased, the wife of the deceased is also expired. Petitioner is the only legal heir.
So if you are the only legal heir, where is the requirement of letters of administration then?
My lord, I have shares, my lord, I need to transfer the shares. I have shares of company.
Then for that you need a succession certificate. Why letters of administration? So far as immovable property is concerned, if you are the only heir, you will succeed to the entire estate. Then so far as only movables are concerned, why letters of administration would be required?
What we call a legal heir certificate. But since the company has asked
For the immovable properties, nothing is required because you are the only heir, you will inherit them. Nothing is required, you will inherit them.
But I need this letter of administration only to produce this before the.
That would be done by succession certificate because those are movables.
Yes, my lord, the letter of administration, I need this letter of administration only to show I'm willing to pay the required amount which I need to deposit as the bonds. How it has been done for so long, my lord. Letter of administration is being granted for transfer of shares.
Very well, not today. Calculate to the benefit.
Wait for the will dated 16 December 2016 by wife, daughter, and the son. All of them have consented.
His mother, father?
What?
His father and mother?
Father, all deceased. Both.
Deceased.
Yeah. The death certificate is also annexed. Both his father as well as his mother.
Where?
Page 6, para 6, page 3. Para 6.
Your mother and sister have consented.
Originated from there, but itself
I don't have determination.
Great. In fact, I identified this to my lord's officer on the very first day. I also felt so.
Yes, because I have from 2023, the PLA is of 2026. So the suit will also be of 2017.
Yes.
Suit will also be of 2017. So I don't have determination.
Yes. It should relate back to the first date.
Has to.
Yes. Great.
Private, sir. The service of the private respondent has been affected.
I'm for the private respondent number 3, Lord.
Who is appearing to CSC?
Purchaser of a soft
Mr. Mukherjee, CSC, who is appearing?
Not Ayush is second, but
Where is he?
So petitioner has purchased the software.
Your other side is not there. CSC is not there.
Also, this is last occasion he appeared.
Yes. Last occasion here he appeared.
New connection due to obstruction of the private restaurant. I'm not getting it.
But I cannot dispose it off in the absence of CSC. They should be there. I'm passing it over.
I have been instructed to attend this matter along with Ayush. The department.
Yes. What is your instruction then?
Also, I have already paid the entire requisite fees.
Passing it over. Let him come. Pass over. Pass over. Next. পাস ওভার করে রাখুন একবার, কারণ এই হট করে ধরেছি তো একটু আসতে অসুবিধা হবে। সেকেন্ড কলে যখন কল করব তখন।
CSC minor.
Passed over. Passed. Passing it over because
we're supposed to touch.
Yes, Mr. Bandyopadhyay. What is your instruction?
My lord, my instruction is, my lord, the erstwhile owner of the property, my lord, he was given notice on several occasions, and my lord, through the bills generated, my lord, we claimed the outstanding amount, and thereafter, my lord, the company couldn't be traced. Once it was disconnected for outstanding earlier, he paid the money, we recovered that money, and the reconnection was made. So thereafter, my lord, after some time, my lord, the amount became due, and my lord, he stopped paying the my lord, bills. And my lord, these steps were taken. This is my instruction. Your lordship's query was whether
The company is still in existence.
Maybe, but they are not in that area.
Respect, my lord, the stand to saddle the subsequent buyers all the liabilities possibly, my lord, it's not correct. My lord, I had handed over Justice Doctor's judgment 2020 SCC online. Kindly see paragraph just before 67, which is at page 20. Kindly see the provisions, my lord. Yes, my lord, just before paragraph 67. My lord, deemed termination of agreement. 4.6. Yes, my lord. If the power supply to any consumer remains disconnected for a period of 180 days, when the disconnection has been effected in compliance with any of the provisions of the Act and regulations, the agreement of the license with the consumer for supply of electricity shall be deemed to have been terminated with consequential effect on expiry of the said period of 180 days. This will be without prejudice to such other action or the claim that may arise from the disconnection of supply or related issues thereof. On termination of the agreement, the licensee shall have the right to remove the service line and other installments through which electricity is supplied to the consumer. Here it has been done. The licensee shall take appropriate action against the consumer or consumer in default in terms of the provision of the Act, rules and regulations, apart from any other remedy provided in any other law for the time being in force.
So we have to, my lord, first catch hold of the consumer and default. But that is what contemplated under this regulation. But this cannot be always a pattern that you get hold of a person who is a subsequent buyer, who does not have the, with deepest respect, they do not have access to the electricity dues. Is searching, electricity dues will never come up. And my lord, the Supreme Court judgment, my lord, which I had relied upon in the previous. Yes, the West Bengal part, my lord, starts from para 327. The judgment is, my lord, reported 2023, volume 14, page 431. My lord, paragraph 327 onwards. My lord, I'll be relying on.
Which judgment are you relying
My lord, 2023, volume 14, SCC 431. May I hand over a copy, my lord, on the previous?
You have handed up only the.
Then I attended apology.
It
Justice Doctor's judgment was reaffirmed here.
Yes.
Kindly see the distribution.
Page and paragraph.
Paragraph is 327, page 570.
That the ratio of the judgment is totally in favor of the the licensee.
What is the ratio?
Only the West Bengal part that doesn't shows the ratio settle down in that judgment. There is specific regulation which is looming.
Then you reply.
My lord.
Paragraph 330 onwards. I'll be relying.
330.
It starts from 327. I'll be relying from 330. Because the facts are absolutely identical. Clause 1 of the terms and condition provided that the e-auction was being held on an as-is where-is basis. Here also same. Clause 2 provided that the property was being sold with all the present and future encumbrances, whether known or unknown to the bank. Clause 7 provided that it was the responsibility of the interested bidders to inspect and satisfy themselves about the properties before submissions of the bid. On so and so, the assets of the previous owner were taken over by so and so through e-auction. The registration of the property was done in the name of so and so, who is the respondent herein. On so and so, the respondent filed an application seeking a new connection from the appellant. When the appellant refused, the respondent filed a writ petition before the Honorable High Court. On so and so, the single judge allowed the petition and ordered the appellant to process the respondent's application within a period of 3 weeks. However, by the letter dated so and so, appellant refused to grant a connection in view of the electricity dues of so and so payable by the erstwhile owner in respect of the premises. The respondent again approached the Honorable High Court seeking a direction for the supply of electricity to their premises. On so and so, the single judge of the High Court allowed the writ petition and directed the grant of an electricity connection to the respondent. The division bench, by a judgment dated so, dismissed the writ appeal and upheld the decision of the single judge. In the impugned judgment, the High Court's interpretation largely focused on the phrase any consumer 4.6.4 contained in regulation 4.6.4. Under regulation so and so, a new consumer can be given service connection only if the outstanding dues against the same premises cleared along with the late payment surcharge. The court referred to so and so to hold that the definition of consumer contained in section so does not include an auction purchaser. However, the court held that it is possible to bring an auction purchaser within the ambit if the distribution licensee establishes the fact the premises concerned were connected to the works of the distribution licensing for the in such manner that the supply of electricity can be resumed by simply the applicant was drawn attention to the fact that the supply of electricity to the therefore, the applicant submit that on the date of sale of the premises to the respondent that is also mentioned, the supply of the electricity was disconnected for more than 180 days. Hence, the applicant's contention that regulation so and so is applicable and there is has a superlative effect as it brings the norm of as argued that regulation so and so could be applicable. As argued that and the non-obstant because has no bearing on the operation of regulation. The supply of electricity was disconnected on so and so. The supply is disconnected on which was date of auction and on so and so was the date on which the premises was sold to the respondent. In terms of regulation 4.1, there was a clean termination of the supply was disconnected for more than 180 days. However, so and so requires any consumer to clear the outstanding bills of the premises to be eligible for grant of service connection. In the present case, the respondent cannot be considered a consumer unless an agreement was entered into with the distribution license. That has been reiterated in HON'BLE in auction 335. Auction purchases such as the respondent cannot be termed as a consumer. But to come within the ambit of 4.6.4, there I have to be a consumer. That is the ratio vis-a-vis the West Bengal regulations. In other states, there are regulation specific regulation for charge. I had shown paragraph 117 by sub-regulation they can. It sees 117 once. Although there is some confusion.
117?
117 para. Page 510. In light of the above
Yes.
In light of the above discussion, we are of the opinion that the electricity utilities can create a charge by framing subordinate legislation or statutory condition for supply of enabling recovery of electricity areas from a subsequent transferring. Such a condition is rooted in the importance of protecting electricity, which is a public good. But here pausing here for a moment. The other regulation 2010 says there has to be a nexus, and nexus has to be proved by the licensee. And there is no regulation, subject to my learned senior friends correction, my lord, there is no provision in the sub-regulations or any of the regulations saying that there has to be a charge is created. There is no regulation of such that. And my lord, kindly see the rejection order. Kindly see the rejection order. Page 40. 40. 40.
Yes.
With reference to the application number, this is to inform you that the service connection at your premises so and so could not be provided for the following reasons. Outstanding dues pending to be cleared. And this is the only reason. And my lord, on the previous occasion, I had shown paragraph 87 last portions. My lord, justice specifically held you have to mention the provision under which you are exercising this right. My lord, there is no allegation that I have nexus. There is absolutely no doubt that I do not come within the zone of the definition of consumer. So under which provision they will not allow me electricity connection? My lord, kindly see 87 from bottom, my lord. 5 appellants were not sure. My DVC's appeal 87. The appellants were not 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Well, possibly 10. The appellants were not sure which provision of law was appropriate to be invoked and hence maintained silence by not referring to it. I do not for a moment say the absence of a reference to a statutory provision would invalidate an action otherwise permissible in law. But what was required by the appellants in order to invoke so and so was at least referred to the fact portion of the inclusive definition of consumer as Mr. Mitra had contended, and say that the condition for treating the writ petitioner as a consumer under the new act stood fulfilled, and therefore it was liable to clear the dues of so and so. But there is no allegations, nothing, just a one-line order, unreasoned. And today, if they go back, they will now improve themselves. But I have invested, my lord wanted to know the same, my lord, what was the value? Same value I have purchased. So there was no, nothing had gone down. I can show the same. This is the first one, the reserve price. Same, the same. Find the value at which I have purchased it at page 22, the sale certificate.
Yes.
7 crores, the first property itself. I have purchased at the same price.
Okay, 70 crores. No.
7 crores. Dada.
7 crores.
Yes, Mr. Bandyopadhyay.
Yes, my lord.
You have not established nexus. You have not brought anything on record.
My lord, we need not to, my lord. The regulation 4.6.4 is, my lord, clear. My lord, there is no, my lord, may I read in, my lord?
Regulation 4.6.4, Mr. Bandyopadhyay, has been interpreted by the Honorable Division Bench of this court in this Damodar Valley Corporation matter, which has been cited by Mr. Chakraborty.
Yes.
There it has been said that he should be a consumer. For 4.6.4 to be invoked, he should be a consumer in respect of the premises. When will he be a consumer? It has been defined in the Act. Only if his premises is connected with the works of the licensee. Now, in this case, you have disconnected. There is deemed disconnection after the connection continuing for 180 days. He is not the person in whose name the supply existed. So he is a new consumer. Now the Honorable Division Bench has made a distinction between a consumer and a new consumer, because one of your regulations uses the expression new consumer, other regulation uses the expression only consumer. So this consumer has to relate to the expression used in the Act, 2003 Act, where the premises has to be connected with a licensee. If he was the person whose line had been disconnected and he had sought for reconnection, he would have fallen within the bracket of consumers. But he is not that. He is a subsequent purchaser. Therefore, 4.6.4 may not apply to him.
But my lord, here, my lord, new connection.
Mr. Bandyopadhyay, you have to satisfy on the nexus aspect or on whatever. But how would you? This is your letter. The letter does not say anything.
Very well, my lord. On the first, my lord, on the first occasion, your lordship's view was that, my lord, we should, my lord, inform them about the, my lord, the grounds for not supplying electricity or not giving the connection, because the letter was not clear. Your lordship was about to set aside that letter and, my lord, directing the company to, my lord, inform them afresh. That we can do.
No, my lord, I'll continue to suffer. My lord, let them first.
That we can do.
My lord, this cannot be at the sweet will of the respondents.
No, it was.
Right.
It has fallen from the law.
We do this, Mr. Chakraborty. I will not be in a position to dispose of the writ petition then without giving them an opportunity to.
My lord, for an interim measure, may I be given connection?
Then that will be final relief.
Final relief. That will be final decision.
My lord, subject to correction. One matter, my lord, I had personally appeared where, my lord, we had to pay 25% or 25%, and it was kept to be a fixed deposit. I will be getting recurring interest and will be given the connection, because, my lord, I have brought it to run a business. It's a factory premise. It's a company which is still in existence.
Mr. Bandyopadhyay, if the amount is secured, what is your problem? If you ultimately succeed, you will be paid. You are interested in the money. So far as electricity supply is concerned, he will be paying the current consumption bills till such time the writ is pending. But for an interim measure, he will secure the sum by way of a
The
fixed.
entire outstanding sum.
Yes, he will secure the entire. It's 1 lakh something. He secure the entirety of that.
But if my answer is 25% would
He secure the entirety of that. If
bank guarantee I'll give of this.
bank guarantee will be costlier than the security.
May I say this, subject to correction, I'll give a fixed deposit certificate to them so that interest goes on. I'll give the certificate.
But I cannot take decision right now before your lordship. Well, I have to take instruction. Your lordship knows, my lord.
It's a court or in a money claim also. My lord, I can.
But if your lordship ask me, then I have to take instruction. I cannot on my own, my lord, take this decision. Well, let them come with the concrete proposal. Whether it is
No question of proposal. I will have to decide this. Only thing is, at this stage, I cannot decide without affording you an opportunity of filing writ petition. But here, prima facie, it appears that he is not hit, neither hit by 4.6.4, nor have you shown any nexus. So on that ground, I can
if your lordship,
prima facie order.
If your lordship so permits me, my lord, then kindly, my lord, adjourn this matter, my lord, giving me time, some time, my lord, take this.
How much time?
1
I
week
can
time.
give it tomorrow.
Tomorrow, tomorrow, by tomorrow.
No, my lord.
We'll fix
Your
it.
lordship knows, my lord,
The
this
certificate.
decision cannot be taken by the station manager, my lord. It has to be taken by the higher authority.
On prima facie satisfaction, I will say that this should be there, and he will secure the sum. It is not that I am leaving him free. He
Yes,
will
my lord.
secure the sum.
Lord, I will talk with my lord client, my lord, and will take instruction, my lord, whether they are agreeable or if your lordship, my lord, gives me that liberty, then, my lord, if your lordship so desires, then, my lord, I can take that instruction. Whether, my lord, in what way, my lord, that can be done. If they wants to secure, my lord, if they want to secure, my lord, then either whether by the fixed deposit certificate or by, my lord, bank draft, or in which way it will be commensurate to.
It is not going to be paid to you at the moment. Because if it is paid to you, then in that case, there is no point in considering it. If it is paid to you, there is no point in considering it. He will keep the sum secured so that it can be paid to you.
Then, my lord, if it is interpreted that, my lord, he is not a consumer, but then, my lord, when he becomes the consumer, if your lordship, my lord, holds that since he is not a consumer at all right now, then this provision is not applicable. Now, if we give connection, my lord, they will become the consumer. Thereafter, my lord, we will be, my lord, then interpreting in that way, my lord, they will be entitled, or we will be entitled to get recover the money from them.
No,
not then. That is not
Because
that is not the provision.
Yes,
It's
my lord, in that case, it is in that case,
is something I have.
No, my lord. Apart from jokes, my lord, they are securing for the.
Chakraborty, suppose I give him 7 days for filing affidavit, 3 days for reply, 10 days. What will happen? I'll make it peremptory. Instead of cutting out all of this.
My lord, 10 days kindly fixes a time, my lord.
I'll fix a time and date. You file
No, my lord, 7 days. Only, my lord, 10 days, my lord, 10 days.
No.
10 days.
You have already got enough time. No 10 days.
No, my lord, I was not prepared for, my lord, the affidavit opposition.
Why not? You should have been.
No, your lordship only, my lord, directed me to take the instruction.
So you have come with oral instructions.
I'm not bargaining, my lord. 10 days.
No.
Instead of 7 days, my lord, 3 more days.
7 days, you please file it, because this you cannot make somebody suffer without electricity because they won't be able to file it. If the court wants, they have to do it in 3 days. So you have to do it in 7 days. If you don't do it, you will lose your chance. I'll make it peremptory. Please don't do that. In every matter, if you want 10 days, why? What will the authorities do?
Other matters, my lord, I have paid for 2 weeks. My lord, here, my lord, 10 days only.
No, so here
I leave it to your lord. I leave it to your lord.
Do it 7 days.
I leave it to your lord.
Every matter, it can't be according to the authorities' own sweet will that they will take time. Why can't they do it in 1 day? Why can't they do it in 2 days?
This is not that, my lord, stereotype matters, my lord, the high stake matters.
Question of
That's why I
high stake matter. It's a 1 lakh something matter where you have made it high stake because you don't want to file your affidavit. The dues are in the zone of 1 lakh.
Very well.
Having heard When are you returning?
My lord, I'll be available from 31st.
Can we keep it after that then?
My lord, 25th kindly, my lord, or else they will not file. My lord, let the pressure be there. They will not file. I knowing Mr.
No, then I'll extend both the dates and fix it in.
My lord, kindly, then my lord, may I only request, kindly don't give any time, but within the first 15 matters, then will help. Because the computerized my lord, matters go down. That's why. 31st, my lord, within 15 matters, first 15 matters.
31st you'll be here.
Yes, yes.
তাহলে ওই টাইমটা লিখে দিন, affidavit in opposition within Mr. Bandyopadhyay, you have got your 2 weeks.
My,
Please file it, don't fail the time.
my lord. My,
I'm grateful, man.
পাস ওভার গুলো একবার কল করে দিন যদি একটা দুটো হয়ে যায়।
দিয়েছিস?
I don't think there will be time anymore because it's almost 4:30.
Lord, 34 minute I have been requested by Mr. Ayush Sharma that to pray for a not today in this matter, my lord. Because
why?
My lord, because the instructions are not with him as of now.
You should have been ready.
My lord, there is a my lord, there is a my lord, there is a lack of communication between the department and him, my lord. He has just prayed, my lord, just for a not today. Just for a not today.
So kindly see, this is a only there is the bill of disconnection. I have paid the entire private restaurant obstructing from giving effect of the electricity. The meter room adjacent to my shop. And there is no access of the private.
My lord, he has been instructed right now that private respondents are my lord, creating obstruction. If we may not get police assistance, my lord, we can go ahead with the connection.
Yes, what is your objection?
My lordship, the objection regarding, first of all, the petitioner have not annexed any document showing that he purchased that property. Lordship,
He is not required to show documents of purchase. He may not be the
Lordship,
owner.
I am a co-owner of that property, Lordship. Without my consent, this kind of transaction was happened, Lordship.
He is in possession of the property or not?
Lordship, that is totally disputed. As because he cannot get the
You have
position.
conducted the inspection.
Yes, my lord, inspection has been conducted, my lord. Only thing is, my lord, installation of the loop meter, my lord. The moment we get police assistance, my lord, we'll be able to.
Do it.
Yes, my lord.
What is your document of possession, Mr. Mukherjee? Yes. And how? What is your status? What is your status? What is your status in respect of the property tenant?
I have entered development agreement with the development.
Development agreement with whom?
With one alleged construct developer.
Construction developer starts on page 29.
I didn't understand. Development agreement with the developer means who are you?
I'm the owner of one of the shop rooms. Does it kindly see the photographs?
And you want electricity connection for your shop room?
Yeah, shop room, small shop room. Unless you kindly see the photograph there.
If your lordship kindly consider page 27.
Peter with the adjacent. And you see the photograph. The meter room and let's see the right
So
side.
this is photographs I will not see. And who is the private? Who is the private respondent? Answer the quote first, then.
one of the code.
One of the co-owners. Co
Right, that says deeds that registered.
the private respondent is also owner of a shop room.
Lordship.
So
It's a commercial building.
the
Ground floor is commercial.
the first floor is the residence here.
So both of you are owners of shop rooms. Then why are you objecting unnecessary?
Lordship.
It is
I'm not objecting on that regard, Lordship.
Then
Without my consent, that property has been transferred. If your Lordship kindly,
property transfer, he is not getting any right because of the electricity.
Lordship,
Electricity
that
will make it clear
Lordship,
that it will not
create any
special right
equity.
or equity.
Lordship,
If you feel that there is any title dispute, you thresh it
Lordship,
out before
for
civil
that reason, they have filed a title suit also.
court.
I
Let
have
it be contested.
Lordship.
Let the title dispute be thrashed out before the civil court.
Lordship.
He is in possession. He will take electricity supply. You are in
Just
possession.
subject
you also
to
take.
subject to that it will not create any
Yes, it will not
right,
create
Lordship.
any right to title and equity.
96 page 26, the agreement, development agreement, between and developer.
With him and the developer, not with the landowner, Lordship.
এটা ওই ইলেকট্রিসিটির মামলায় দিয়ে দেবেন আগেরটা যেটা তন্ময় যেটাতে ছিল
unethical.